correction of the order. Can it be taken tomorrow, madam?
Correction of order?
Yes.
All right. Yes.
May it please your lordship, with the consent of the other side, my lord, I beg to mention item 10, my lord. Lordship, kindly this matter may be taken up after the vacation, my lord, due to some personal inconvenience of my senior, Mr. A.K. Bhuya, my lord.
A mention is made by MS
B. Bora.
P.
B. Bora.
B for Bombay?
Bombay.
B. Bora, Learned Counsel, to the effect that the leading counsel, Mr. A.K. Bhuya, Learned Counsel for the petitioner, has some personal difficulty today and accordingly seeks accommodation in the matter. Prayer is not opposed by the other side. List this matter again on after vacation of the date. Next.
May I please? I beg to
Date, my
mention.
lord? 26.
I beg to mention item number 8 and 9 of the daily list, my lord.
Yes.
My lord, I am mentioning on behalf of Mr. P.J. Sekia. He has some personal difficulty today. I pray for adjourning this matter.
When
Next week, my lord.
in item number 8 and 9, a mention is made on behalf of Mr. P.J. Soikia, Learned Counsel, appearing for the petitioner, to the effect that due to personal difficulty, don't say that. As prayed for on behalf of Mr. P.J. Soikia, Learned Counsel for Learned Senior Counsel for the petitioner, list this matter again on
20th of June, my lord.
28
20.
20.
Obliged.
May I please, Your Lordship, I beg to mention item number 5. The engaged counsel, Miss S. Nazni, is having some personal difficulties today, Your Lordship. Kindly matter be fixed after 2 weeks.
Your name?
P. Roy.
MSP Roy, Learned Counsel for the petitioner, submits that the engaged counsel MS
S. Nazneen.
Mr.
Miss S. Nazneen.
MSS
Nazneen.
Nadini, Learned Counsel for the petitioner, has some personal difficulty today and accordingly seeks some accommodation in the matter. Prayer is not opposed. List this matter after
2 weeks.
2 weeks on a date to be fixed by the registry.
Obliged, Your Lordship.
For admission, item number 1 to 4.
May it please your lordship. In this case, lordship, earlier there is an order for
Yes,
bringing
record.
the records.
Mr. Talukdar.
We have not received. I have communicated, but once we've gotten information that the records are not traceable. But these are similar cases, Melody. In item number 4, we have filed our affidavit.
No, but what about the records?
Records I have already communicated, but
You are yet
yet to receive.
receive. Because we had given you, in fact, on the last occasion, on your assurance, this matter was posted today. Hoping positively you would have placed.
Possibly they could not trace out the...
Anyway, then, you see, I'm posting it, I'm giving you further 2 weeks' time.
After
In the meantime, if the records are not traceable, what is to be done, you
Then
inform.
Lordship will-
Yes,
My
you
Lord.
get it by way of some instructions, place it before the court.
Man,
Right.
we have already filed one affidavit in item 4.
Correct, but that you have filed long back, isn't it? After that, the records were called
My
for.
Lord.
So you give us the instruction.
Man.
Mr. B.J. Talukdar, Learned Additional Senior Government Advocate for the state respondent, submits that the concerned office is yet to send the records as called for by this court earlier. Stop. He accordingly seeks some more time in the matter. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry.
Deeply.
1 to 4, right?
1 to 4, lordship. Lordship, may I pray to make it as a part-heart matter as your lordship?
No.
Deeply.
Obliged.
Item number 6.
May it please, your lordship.
My lord, the matter
relates to cancellation of a fair price of license number.
Yes. Pleadings completed?
Yes. Pleadings completed, Miller.
Yes.
The petitioner initially was so cause for suspension on 14/6/2022. My lord will find the so cause notice as page 32.
Page?
Page 32.
Yes.
Your Lordship will find here, based on a report of an inspector of FCS in Silchar, this so cause notice was issued, my lord. And this report was never furnished to us on the first contention.
Based on a report the so cause was given?
Yes, based on that report. And this report was never furnished to us.
Where have they mentioned about the report?
The first line, whereas it has been reported by D. Patak.
Yes, Mr. Kaushik.
My lord.
I've got it.
It is observed from record, my lord.
I've got it.
Yes.
Got it.
My lord, will kindly see what is the charges in that, in this so cause, my lord,
Yes.
for suspension.
Yes.
It is observed from records shown in the online that you are not issuing the PDS commodity through EPOS machine till date. A lot of ration card under your shop till remain unseated. So and so should not be suspended. Now, my lord will find this suspension. I replied to this at page 34.
Page 34.
Page 34. Here I have taken a plea, my lord, that this EPOS system has been newly introduced, my lord, and I did not have the knowledge to operate the system, and there was no training given.
EPOS machine.
EPOS machine.
Yes. Yes. Then they give
Then
the order at
the suspension
35.
order at page 35. Now here your lordship will find that apart from this so cause,
This is what is challenged.
my cancellation as well as suspension both. Page 35 is the suspension order. May I just read it? my lord?
Yes, please.
My lord. Seen and paged the inquiry report dated
Rupa.
24/8/2022.
Assam Public Distribution of Articles Order, Kentucky. Yes, please.
My lord. Seen and perused the inquiry report dated 24/8/2022 submitted by C so-and-so, Inspector of so-and-so, regarding anomalies, irregularities found against so-and-so under so-and-so. From the above inquiry report, it reveals that during the visit, fair price shop was found closed. After opening the shop, it was found there was no stock and price board displayed inside the shop. The large quantity of schematic rice in bags were found lying in the fair price shop. A fair price shop agent unable to produce the books of account. Large number of beneficiaries tagged with the fair price shops are yet to be seeded with the ration card.
A
Along with
lot of anomalies detected.
these are the charges which was not there in the time at the time of so called.
Yes, but after inquiry, this has been found.
After the reply, there was no such inquiry. Hearing was taken later on after this suspension. So, your lordship has found that in the so cause there was only one charges for which I was so cause, that I had not used the
No,
EPOS
but if
message.
suppose there is one charge in the show cause and thereafter a preliminary inquiry takes place and in the inquiry certain more anomalies comes forward,
Well,
then what is to be done?
because APDA rules, Rule 15, my lord, it gives two penalty, suspension and cancellation or cancellation. So suspension itself is a penalty, my lord. So in the so cause, I was never been so cause for these charges which has been leveled against in the suspension order.
So according
There
to
was-
you,
there was no-
show cause as regards these allegations.
These
are concerned.
allegations.
This is your
Yes. First,
argument.
in connection to the suspension. Thereafter, my lord, after that, I have been suspended.
Do you have a copy of the?
My lord, I'll
If required, I think it's available online.
it's available online.
Can
I
you-
have a
can
copy.
you get a
Your
printout?
lordship can.
It's a 55 page. Then no need. I think we may have a copy in the library. Can you check?
Rule 15 is the power.
Yes,
invoked,
I'm
my lord.
reading. I'm
My
reading. It may be cancelled or suspended.
or suspended.
And
And
it says no order of cancellation shall be made unless the licensee has been given reasonable opportunity of stating his case against the proposed cancellation by an order, but during the pendency or its contemplation of the procedure of cancellation of the licensee can be suspended for a period of so and so, giving opportunity to the licensee of stating his case. So is this done or not?
if it is in contemplation of a cancellation, my lord, then the suspension can be only for a 90 days period. Now, first clause 15(1), my lord, it says that if the licensee contravenes any terms and condition of the license, then it either can be suspended or cancelled. Now,
Yes.
this suspension here in this case was not in contemplation of the cancellation, my lord. Your lordship will find the suspension order. There is no.
But in your case, it has already been cancelled.
Cancelled. That is-
Correct.
yes, we are
So
challenging the
now,
cancellation also.
If it has been cancelled, what you really need to show before
My
this
first
court
limb of argument is that
whether
that-
before cancellation a fair opportunity has been given to you or not.
yes, that would be my first limb of argument
Let us confine ourselves to that.
to the cancellation.
To the cancellations then.
My lord.
Because you
Now,
will get
thereafter-
nothing by.
Yes,
Suppose for some reason the
But
suspension
I'm just
is wrong.
trying to
also.
show the
I have
the
understood.
part
According to
how
you,
arbitrarily they have proceeded.
but now you show me whether opportunity you've got.
My lord,
Yes.
before the cancellation, a so-called notice was issued, page 37. The same charges
So
that have
after the suspension, another so-called notice.
another so-called notice. Page 37 is the so-called notice for cancellation.
Yes.
Based on the same report of the inspector of FCS and CA,
Yes. Now all these things are already mentioned
all
here.
already mentioned the same charges
So
that
you have got opportunity.
My lord, the opportunity which has been given, I have replied to this, my lord. My contention which was given in the so-called reply, nothing was taken into consideration.
That is another thing.
Yes, I'll come to that, my lord.
That is on merit. That is the under wisdom. They may have not found your reply sufficient.
My lord, even the
How can this court now go into that?
my lord, even the inquiry which was held, the inquiry report on the instruction of direction of this honorable court, my lord, when it was pointed out that the hearing was taken by one officer and the order was passed by the another officer, there was a direction from this honorable court to produce the inquiry report and as well as to file an affidavit as to the effect
has been
that
done.
whether that inquiry report was ever furnished to us or not. They filed an affidavit, inquiry report has been brought on record, and they have filed an affidavit that inquiry report was never been furnished to me.
Which inquiry report?
The inquiry report pursuant to the so-called on cancellation.
The page 37 is the show cause. Page
So-
38 is your reply.
38 is the reply, my lord.
And-
Kindly.
And then where is the
Then, my lord,
cancellation
I
order?
was called for a hearing on page 41.
This is hearing.
This is hearing in connection to the suspension.
Yes. Then
Then, my lord, after the hearing, I have filed a written statement at page 42.
final order is at
Final order is
44.
at page 45.
45.
Page 45.
Let's read that.
My lord. Whereas retail license dated so and so in favor of fair price under Meherpur Kishanpur Cooperative Society was placed under suspension by order dated so and so for violating provision of clause 10, 18, 21, 25 and 26 of the APDA as well as terms and condition of the license 3A 78182 under the APDA 1982, whereas hearing was conducted by the Executive Magistrate Kasar. During hearing, Sri so-and-so stated that he has the stock price board but have not displayed it on the day of visit of the Inspector FCS. The dealer could not
Which
substantiate.
inquiry report are you talking about?
No, that your lordship
because you
will.
see the inquiry which is mentioned in your suspension, ultimately in the show cause notice, everything has been put to you. Right?
Yes.
Whatever the findings were was put to you. Therefore, you cannot say that you are prejudiced. You are aware of the findings of the inquiry. Right?
No, the inquiry report was never been furnished to us.
The findings were put to you. The incriminating circumstances that came out
in
against
the inquiry, my lord, I'll say,
Yes.
so the inquiry report and the findings are completely different.
Case, Mr. Kaushik, that since the inquiry based on which the show cause notice was issued was not furnished
Was
to
not
you,
furnished. The report.
therefore you have been prejudiced and there is a violation of natural justice as well as this clause 15.
Clause
Is that
15.
your case?
That first. Second, my lord, even I have been given an opportunity of being heard. My lord, the factors which I have brought in before the inquiry, that was never been considered, my lord.
That is
on
your
the
second.
contrary, yes, my lord.
That is your second argument.
That is my second argument.
And
The contention, that is the findings in the order and the inquiry report after the hearing, my lord, are inconsistent. Are inconsistent.
inconsistent. What is your stand?
Yes, my lord. Although my lord, inquiry report was not furnished earlier,
That's an
my lord.
admitted stand.
Yes, my lord.
So that is one of the issues. Whether non-furnishing the inquiry would cause
vitiated the whole
prejudice.
proceeding,
Because section that's
Section 15, my lord, does not
subsection
provide.
2 says no order of cancellation shall be made unless the licensee has been given reasonable opportunity
Yes, my lord.
of stating his case. Now, if you do not furnish the inquiry report, how can they be said to have been given a reasonable opportunity?
On the basis of inquiry, my lord, so cause was issued, my lord.
Correct, but they do not have the inquiry.
Yes,
Are
yes.
you carrying that authority, Mr. Kaushik?
Yes, my lord. In fact,
Which one?
Santanu Medhi, my lord.
Huh?
Santanu Medhi,
Yes.
where our Honorable High Court has said, merely giving a show cause or a hearing would not suffice. A inquiry has to be as it is, the punishment is a cancellation, so it cannot be done in a hasty manner, my lord.
No, there are also decisions non-furnishing of inquiry report.
My lord, yes. That
Are you carrying?
No, that I am not. But this order of this judgment of our High Court, my lord, it includes all this, my lord. If your lordship comes to page para 20 of this judgment, my lord. Para 20.
Yes, cancellation of license.
Cancellation of license is a drastic power directly affecting the life and livelihood of a licensee. Unless the violation of statutory provisions by the licensee are serious and proved in course of inquiry, such as course of action should not be resorted to hastily.
This is all right, but I think there are also decisions on non-furnishing of inquiry report. Get hold of one. I can post it on tomorrow or Monday or Tuesday, whenever you want.
I'll
Tomorrow or Tuesday.
Tomorrow is so convenient.
Tomorrow is okay. I am not hearing you further because on this ground, prima facie, this court is of the view that read with 2 of 15 because admitted position inquiry report has not been furnished. Now, if that causes prejudice, then the reasonable opportunity is not met. Then I don't think this court needs to go further into the merit of the case.
In fact, your lordship will
Even,
just
my lord,
try allow
in
me
the
to.
whole proceeding, my lord, he never sought for the inquiry report also.
See,
my
that is different. This is act or rules. What are these called? The APDA
lord.
orders?
Public description order, my lord.
This is, they are
Article-
referred as clauses, sections?
Clauses.
Clauses. So the clauses, sub-clause 2 of clause 15 is very clear, right, Mr. Chetia?
Yes, ma'am.
Reasonable opportunity. Now, what would reasonable opportunity mean? That whatever you have against the, everything has to be given. No doubt that you have given the sum and substance of the inquiry. But on what basis those findings have been arrived? Those have not been disclosed to the petitioner. Therefore, the petitioner is prejudiced. Isn't it, Mr. Kaushik?
Yes. In fact, my lord,
So, in that case, there is a gross violation of natural justice. I am on that right now.
yes, of course, my lord.
So, if you,
I'll place it.
since I am confining myself to only this, so assist me with those authorities.
If your lordship just read para 20 and 21 for a moment, my lord. This
I have read para 20, Mr.
21, my lord, even the same matter, my lord, in fact, the facts are same. The
See here, it says that reasonable opportunity, but they are not specifically dealing with the non-furnishing of an inquiry report.
No, para 21,
Yes.
my lord, it indicates
The record
the
does
record
not
does not
indicate.
indicate that the copy of the report was furnished to the petitioner unless the licensee is confronted with the allegation as appearing in the inspection report.
All right.
An effective reply.
I stand correct.
Yes.
Then I am disposing it right now.
Yes, my lord.
There is no point of keeping this matter.
Yes, my lord. In this case, now, my lord, we have already furnished, my lord. After
You see,
They-
you are at liberty to
Don't-
take any action or proceed in accordance with law.
Yes.
That liberty is with you.
Oh, yes, yes.
Correct.
Yes.
So therefore, I said I'm confining myself only to this issue.
Right.
I am not going into the merit.
Yes, my
You
lord,
can
since-
furnish and do whatever you want to do.
Yes, my lord.
Right.
Since my lord, we have now furnished him, my lord, he can
Thereafter,
reply-
you can proceed.
Yes,
That is up to you.
yes, my lord.
But that also, it's not like you simply give him an order of cancellation. You have to give him formally. What you have done is you have furnished by way of an affidavit. So you take everything from beginning.
Yes.
You furnish him a copy
Yes, yes,
and then
but-
start if you
Yes,
want.
but
But I am
if
not
it-
going to say all this. You
My
know
lord,
what
will
is
not
to be
indicate
done.
that liberty because they will.
I am not going to indicate. What is
That
available?
liberty always
what
remains
is
with them.
available in law is available.
Yes, it always remains with them.
Mr. Kaushik, what is this? The other case, Mohanpur.
My lord.
You have given two cases.
Oh, okay.
Which is this 3778 writ petition?
3778. My lord, here also in this case, this judgment was relied on by our High Court, and this honorable court also dealt with the proportionality of the punishment, my lord.
This is item number 6.
Item number 6.
Item number
Item
6.
6. Okay, disposal. Heard Mr. B. Kaushik, learned counsel for the petitioner. Stop. Also heard Mr. M. Chetia, learned government advocate for the state respondents. Stop. The petitioner, by filing the instant petition under Article 226 of the Constitution of India, is challenging the cancellation order dated 22/2/2023 issued by the respondent number 6, i.e. Superintendent Food Civil Supplies and Consumers Affairs, Silchar. Stop. The facts of the case is that, next paragraph, the petitioner is a fair price shop agent under the Meherpur Krishnapur Cooperative Society Limited in Kachar district of Assam. The fair price shop license of the petitioner, being license number 2007 of 1993-94, was issued by the respondent number 7 under the provisions of Assam Public Distribution of Articles, Order, 1982. Stop. The first SCN is at page. Yes, I got it. 32.
Page 32.
By order dated 14th June 2022, the superintendent is respondent number?
Superintendent.
The respondent number so and so.
6, my lord.
Respondent number 6 issued show cause to the petitioner on the basis of a report submitted by Inspector FCS and CA Silchar that it is observed from records showing in the online that the petitioner is not issuing PDS commodities through E-POS machine. Stop. In view, pursuant to such show cause notice, the petitioner on on 16/6/2022 submitted its written reply stating inter alia that since the petitioner has no knowledge regarding the utilization of EPOS machine through online regarding utilization of EPOS machine, the said machine could not be used. Stop. Thereafter, the petitioner was placed under suspension by order dated 5/9/2022, wherein it has been stated that upon inquiry, it reveals that /1 to 7 asa in the at page, this is page number
35.
35. Sailoba 1 to 7. Guteketa didiba. Thereafter, on 5/9/2022, another so-called notice was issued to the petitioner as why the license issued in favor of the petitioner under the APDA Order 1982 shall not be cancelled. Stop. Next year. Thereafter, a written reply was submitted by the petitioner on 5/9/2022.
13/9/2022. Page 40.
13/9/2022. A hearing also was conducted in connection with the suspension of the petitioner's fair price shop, in connection with suspension of petitioner's retail license of fair price shop on 20/10/2022 at 2:30 p.m. Stop. Consequent, resultantly after such hearing, the respondent number 6 by order dated 22/2/2023 cancelled the retail license of the petitioner. Stop. Mr. B. Kaushik submits that the aforesaid cancellation of the retail license of the subject fair price shop of the petitioner is in contravention of clause 2 of subclause 2 of clause 15 of the APDA order. Stop. He submits that the APDA order contemplates that a full opportunity be provided to the petitioner before issuance of the cancellation of the retail license. Stop. It is he specifically submits that the inquiry report based on which the show cause notice was issued was not furnished to the petitioner, for which there has been a gross violation of the principles of natural justice. Stop. Next para. Mr. M. Chetia, learned government advocate, concedes that the inquiry report was not submitted to the petitioner. However, he submits that non-furnishing of the inquiry report shall not prejudice the petitioner inasmuch as the findings of the inquiry report were mentioned in the show cause notice dated second show cause notice
5/9.
Second floor.
dated
5/9.
5/9/2020.
5/9/2020. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. In order to appreciate the rival contentions of the parties, pertinent to refer to subclause 2 of clause 15 of the APDA order 1982, which is reproduced hereunder for ready reference. Mr. Kaushik, you later on take
I'll
this.
collect it.
Flag করে দিছো, huh? Quote unquote. তাৰপিছত লেখা, a perusal of the said provision indicates that before cancellation of the license, the authorities has to give the licensee a reasonable opportunity of stating his case against the proposed cancellation by an order. Stop. In the present case, admittedly, the inquiry report based on which the show cause notice dated 5/9/2022 was issued to the petitioner to show cause as why the petitioner's license shall not be cancelled was not furnished to the petitioner. Stop. Pertinent to refer to paragraph affidavit. Where is it said?
But in the additional
affidavit, matter paragraph 3.
paragraph 3.
Additional affidavit.
Yes.
Page 49.
Page
49.
49.
$49. No, it's not.
49 will not be proper.
Wait.
The lordship will find the
Additional affidavit by R6.
by R6.
And in which paragraph?
Paragraph 3.
No, not paragraph 3.
Paragraph 3, my lord.
Mr. Kaushik.
Maybe 59. Wrongly numbered.
Maybe.
59, sir. 59.
But did you go first? Report.
Page 65.
You just mark it. Have you marked it? Teneke loe hok. Pertinent to refer to paragraph 2 of the additional affidavit filed on behalf of the respondent number 6 on 23/11/2023 in terms of the order passed by this court on 12/10/2023. Stop. That's it to be 2 to quote kore diba. Paragraph 2 at page 65. Pink flag.
Paragraph 3, my lord.
3. Paragraph 3. Yes, paragraph 3. In fact, I can quote both 2 and 3.
2 and
it
3
will clear it.
Yes.
Paragraph 2 and 3.
2 contains the order.
That's right. Therefore, it is an admitted fact that before passing the impugned cancellation order, the said inquiry report was not furnished to the petitioner. Stop. Next para. Pertinent to refer to the decision of this court in 2014 3 GLT, pertinent to refer to the decision of this court in the case of Santanu Medhi versus State of Assam, reported in 2014 3 GLT at page 253. Stop. Paragraph 20 and 21 of the aforesaid judgment is reproduced hereunder for ready reference. Stop. In fact, the aforesaid decision of this court squarely covers the issue in hand. Stop. Accordingly, this court is of the considered opinion that non-furnishing of the inquiry report to the petitioner has caused gross prejudice and is in violation of the principles of natural justice as well as the provisions of the APDA Order 1982. Stop. Resultantly, the cancellation order dated 22/2023 issued by the respondent number 6 stands is illegal and is accordingly set aside and quashed. Writ petition allowed, disposed of. I'll make some editing. Anything?
Direction for renewal of the license. They have to renew it because it's cancelled.
When it's cancelled, then obviously they will have to renew. Why do you
indicate to restore?
If I do not give any direction as regards their propose what has to be said and done, why should I record this in your favor? Whatever has to be done will be done.
Yes.
If tomorrow that is not done, then
one thing, my lord. My submission with that can be my lord record because my lord they can
submission about
submission about my lord initiation of the proceeding, my lord, FS, my lord.
Needless to clarify that the respondents are at liberty to proceed in accordance with law. Stop. Needless further to clarify that is this record necessary?
Why don't just indicate consequential?
That consequence cancellation of the term, consequent cancellation, consequent setting aside of the cancellation order shall not be a bar. No. Needless further to clarify that the respondents are at liberty to renew the retail license of the petitioner's fair price shop in accordance with law.
Grateful, man. Highly obliged.
I have my office has given a photocopy of the order, so you can take back your book. Thank you.
Highly obliged, sir.
Returns.
My lord, we are just receiving the copy yesterday, my lord. So I have submitted the copy to the learned friend, my lord.
Just now I have.
You have filed?
In the process.
In the process?
Just now I have submitted copy to my.
Let them file it. So you have given, you are yet to file, but you have given an advance copy.
Copy has been served to the petitioner.
Of the draft affidavit?
No, it's final.
Oh, it's filed.
Finally.
M. Borman, learned government advocate for the state respondent, submits that return has been filed, that the affidavit
during the course of the day.
That the affidavit in opposition shall be filed within the course of the day. Stop. She further submits that a copy of the said affidavit in opposition is already furnished to the other side. Stop. List this matter after 2 weeks on a date to be fixed by the registry.
My lord.
And my lord, the item number 15 also, my lord, on the same issue, my lord, analogous matter.
7 and 15.
7 and 15, same
Yes,
matter.
my lord. On
There
last
also
of-
you have filed.
That already
In
filed.
that,
Already
it was
filed.
Yes.
So in 15,
Stand is similar, my lord, in both
in
the
item
cases.
15, Tumikoba, in view of the order list along with WPC 4560 of 2023.
On 25, this order is already been
Alright.
there, my lord.
7 and 15. होगा.
highly obliged.
Item number 16.
Lordship, let the matter be taken after some time. Mr. Esbora will appear. He's on leave.
Sometime.
May it please your lordship.
APP, PP, anybody there?
May it please your lordship. As regards item number 17, my learned friend Mr. Bora, who had just gone outside for a while, so he'll be after some time. Let this matter be passed over for him. He has informed me.
Okay. Even the PP is not there. Mr. Chaudhary, can you kindly inform one of the PP also?
I'll do.
But there are not much matter on board.
Yes, even our matter is also an item number 19.
All right. Yes, Mr. Chetia.
May I please the Lord.
Item 11 and 2.
Lordship. Lord, matter pertains to Entry Tax Act, Lordship.
Yes, where is the other side?
Lord, Finance and Taxation.
Are you there in this matter? No. Who is appearing other side? B. Chaudhary.
My Lord B. Chaudhary, sometimes my Lord Gogoi, Mr. Gogoi, B. Gogoi.
Mr. S. Chetia, Learned Counsel, is present for the petitioner. Stop. However, when the matter is called, there is no representation on behalf of the taxation department, comma, for which the matter could not be proceeded for hearing. Stop. List this matter again
After vacation, what?
at a date jog after vacation.
After vacation.
After vacation. After vacation.
After vacation, yes, but do you want the order as dictated to stay, or you want someone's name to be recorded?
Mr. B. Gogo's name may be recorded.
Delete that order. Due to paucity of time, this matter could not be taken up for hearing. List this matter on
Any day after
vacation day.
Deeply obliged.
Hello, bless
My Lord, let it be on some other day, 23rd. I have some. Lordship. Deeply obliged.
Yes, next matter, please. Restrain order for running oil mill. You are for the respondent?
Respondent number 6.
But petitioner, Mr. Bora, your name is shown. Item 12. Unless it's some another as Bora.
Maybe, not.
It's a 14 matter. Have a look. Not you, right? Yes?
I'm on behalf of respondent number 5.
None appears for the petitioner when the matter is called. Respondents are represented through their respective counsels. List this matter on Tuesday date with remark for dismissal.
May it please your lordship.
Yes.
This matter relates to compensation for erection of powerful electric lines.
Compensation for
Erection of powerful electric lines under the Telegraph Act 1885.
Telegraph Act.
Lordship.
Pleadings are completed.
Pleadings completed, your lordship.
Yes, please.
They have filed their affidavit. In this matter, your lordship, this petitioner.
Mr. Das, we can proceed with the hearing. Yes, please.
Yes, this petitioner, your lordship, he is basically a person of unemployed person. In the year 2007, he started a brick clean industry.
by taking necessary NOC from the concerned authorities, and that from the year 2007 the brick lane industry started functioning. So it took the NOC on 18/7/2007 Annexure 1 page 12 from the...
Just one sec.
If you see that the hearing takes a little time, then you can ask Bhargav to go and keep typing his orders and you can call him.
Yes.
Yes. Annexure 1 page 12 is the NOC granted by the...
page?
12.
12.
This is NOC granted by the district administration for
Yes.
starting up the brick lane industry.
So you have started a brick clean industry.
By I have taken loan of rupees 10 lakhs and also invested whatever money I have.
In which paragraph you said about the loan? Just give me the paragraph number.
No, here loan is not, it is just the NOC issued by the competent
No,
authority.
in which paragraph in your pleadings you have
Yes.
said that
Yeah.
after getting the NOC you have taken loan to
Lordship.
set up?
Lordship.
Just give me the para number.
Lordship. It is from paragraph number 3.
Paragraph 3. Okay.
So thereafter, your lordship, in the year 2011, he came to know that the Power Grid Corporation is trying to erect some 400 kV electric lines, and they were seeking to erect it over his plot of industrial land. So he made a representation at page number 13, Annexure 2,
Yes.
on 14/3/2011 to the Deputy Commissioner, requesting him that if possible the line may be diverted through some other lands.
Yes.
So this is the application. Humble submission is that I opened a brick industry, namely Chaudhary Brick Industry in Uttarakhand Part 2, but Power Grid Corporation wants to erect electric line over my industry. When I objected, they are trying to forcefully do the work. Therefore, I am having
All
it
right.
free.
Yes.
So he made an objection at that time that the same may be done through some other land.
Yes.
Thereafter, your lordship, when nothing was happening, he made a representation again at page number 15 on 8/9/2011 to the Deputy Commissioner, praying for a similar relief.
Yes.
That the authority is
Okay.
trying to erect
Then-
the lines. Yes, your lordship. Pursuant to that, your lordship, Annexure 17, Annexure 4, page 17, he again made a representation.
Third representation.
To the Deputy Commissioner under Section 17, where under Section 17 of the Act, a person, if aggrieved, he may make a representation to the Deputy Commissioner to change the
To
lines
DC.
to some lordship. Under Section 17 of the Telegraph Act.
There is a provision.
Lordship will take up Section 17. Lordship has the...
Yes, I have it.
Section 17, removal or alteration of telegraph line or post on property other than that of a local authority. When under the foregoing provisions of this Act,
Please read.
Section 17. As removal or alteration of telegraph line or post on property other than that of a local authority. When, under the foregoing provisions of this Act, a telegraph line or post has been placed by the telegraph authority over, along, across, in or upon any property, not being property vested in or under the control or management of a local authority, and any person entitled to do so desires to deal with that property in such a manner as to render it necessary or convenient that the telegraph line or post should be removed to another part thereof or to a higher or lower level or altered in from, he may require the telegraph authority to remove or alter the line of post accordingly. Provided that if compensation has been paid under Section 10, Clause D, he shall, when making the requisition, tender to the telegraph authority the amount requisite to defray the expense of the removal or alteration, or half of the amount paid as compensation, whichever may be the smaller amount. So here no compensation was paid.
All right. Subsection 2.
Lordship.
If telegraph authority omits to comply with the requisition,
Lordship.
the person making it may apply to the district magistrate.
Magistrate, within whose jurisdiction.
Then,
so I have made a representation.
district magistrate receiving an application may in his discretion reject the same or make an order.
Lordship.
What did the district magistrate do after that?
After that, your Lordship, the district magistrate asked the circle officer to submit a inquiry report in this regard.
Where is that?
Lordship will get the inquiry report at page number 20.
All right. Then?
So here it is clearly stated, may I read your Lordship? The
Yes,
inquiry?
please.
By the circle officer to the district commissioner. With reference to the above, I have the honor to state that I have physically verified the spot and like to report that it is a fact that the alignment of high tension line and chimney is approximately 120 foot high and if the high tension line is allowed to go in the present alignment, then both will intersect at 65-70 feet height. During my field verification, Sri Mahiruddin Chaudhary, the petitioner, has submitted a few copies of petitions, etc. After going through this, it seems that the petitioner is objecting the proposed alignment since the beginning, but his prayers were unheard. Presently, but his prayers went unheard. Since beginning, he has been making repeated.
Yes.
Presently, he, after taking bank loans, constructed the chimney, which has reached almost halfway.
So this is already admitted that you have taken loans.
Yes. To solve the above problems, I am of the opinion that either the chimney be removed from the present place or the alignment of the high tension line be diverted. It may be mentioned here that by constructing an additional tower a few meters away parallel with that of the chimney, the high tension line can be diverted if technically feasible.
So this report is in your favor?
My favor. So thereafter, Your Lordship, the Deputy Commissioner gave a finding at page 21.
So this is also in your favor?
In favor, but the Deputy Commissioner has the view that I should be given appropriate compensation.
From the report and documents, it is said that the petitioner is having so and so
affected.
Is having partially affected.
Lordship.
Is having partially affected. I don't understand the English.
That is the view of the Deputy Commissioner on the basis of the inquiry.
Will tender reasonable amount of all rate. Yes. Then
Your Lordship, since that was the order, I made an application under Section 10D to the District Magistrate
for the compensation.
For compensation. But without giving any compensation, the powerful electric lines were taken over my land. And even then, since even
so
the
your case is for compensation.
Now, since they have already erected, compensation part has remained, Your Lordship, because all these things
So
they
only
have.
for that.
Lordship.
This writ is only for that.
Lordship.
Yes.
No, compensation in the.
They have already approached the Lord Deputy Commissioner, the district judge, my lord, Helakani, my lord, and the judgment, my lord, that I will place before the Lordship at page 49, my lord. He has already approached in compensation of the
49.
49, my lord.
What happened there?
Yes, the Lord district judge, my lord, he has directed for making payment of rupees at 3 lakhs, my lord.
So then what happened? Why again another writ petition?
That amount already we have deposited, my lord.
You have deposited?
Already deposited, my lord.
Then?
Lordship, I have incurred sufficient loss, Your Lordship.
Mr. Counsel, you cannot be approaching multiple forums for the same cause of action.
No, I am agreed by the order of the Deputy Commissioner.
Correct. Now, why did you approach before the learned district judge?
No, I am agreed by the order of the learned district judge. That is under challenge before this honorable court, Your Lordship.
You are challenging the district judge's order?
The district judge order on the ground.
This order cannot be assailed under the provisions of CBC? It can?
Yes, madam.
Then, how will you come under 226?
The judgment passed by the Lord District, that is final, my lord. There cannot be any.
How have you come under 226? Please answer the query of the court, otherwise exemplary cost can be awarded in this case because it looks like it's an abuse of the court's process.
Lordship, actually there is a Supreme Court judgment.
Whatever may be, the facts of the case is very clear. Judgments of the apex court will be applicable in the context of a present case. They are contextual. Now, in this case, you've already got orders in your favor. It is unfortunate that those orders were not complied at that stage. Be that as it may, you have gone to the court of district judge and you finally got an order from there. If you are not happy with that order, you know where to go. But why this 226? How is this writ petition maintainable? Please answer. I have understood your case correctly, isn't it?
Lordship.
Yes.
So because what I am on to Your Lordship, while determining the payment of compensation, Your Lordship, the district judge, the learned court below, Your Lordship, he has not considered the.
Maybe, but you have a alternative forum.
Lordship will take up the matter day after tomorrow, Your Lordship. Because day after tomorrow
Day after tomorrow you will come to court.
Oh, sorry. Next week.
Sunday.
Tuesday.
I'll seek it.
Well, hearing remains inconclusive. List this matter again on Tuesday for further hearing.
I'm deeply obliged.
I'm keeping this part heard.
My lordship.
You address the specific query. You understand?
Yes.
Otherwise, you withdraw and we'll give you liberty. You file wherever you have to file.
Obliged.
Yes.
Item number 14.
Right, please. This,
Yes, Mr. Ganguly.
This writ petition was filed, Manoj, rising out of an auction. Manoj, I am an auction purchaser. I am an auction purchaser under the Surface
Mr.
Act.
Pathak, you're ready?
Yes, sir. It is ready. Manoj, the HDFC Bank, Manoj, which conducted the auction under the Surface Act, Manoj, admittedly the auction land, Manoj, the description was given and the area was given as 2 bighas, 3 kathas and 9 lessers.
Yes.
And Manoj, when after taking possession, when I entered the property, then I found, Manoj, that the actual area of the land is 1 bigha, 1 katha and 4.5.
Sorry, can you repeat?
No, what has happened is that I was the auction purchaser in an auction under the Surface Act. I paid the entire money. A sale certificate was issued to me, and thereafter, I entered into the possession. And when I entered into possession, I found that the area actually sold to me is shorter.
It's
less. This I found when I went to make a mutation entry. When I applied for the mutation, I approached the revenue office. The revenue informed me, and this was confirmed also by the then municipal authority, that the area being short, the namzari cannot be done in my case. And I approached the bank that you have sold me a smaller amount of land than what is described in the sale certificate. So I am even ready as of today also, to take even with the lesser area of land. But the difficulty is when I approach the bank that you correct the sale certificate, because on the basis of a sale certificate for, let us say, the area of land which was advertised to be sold, if I am in possession of, if I am given much lesser, then the revenue authority will not accept that, and my sale certificate will not be registered. They never replied, never got back to me. They said that they literally washed their hands off. They said that we have issued the sale certificate, we are not going to issue anything else. And my representations went unanswered. At that stage, I came to this Honorable Court. Now, in the affidavit that they have filed, they raised 2 principal issues. One is the issue.
They means?
The HDFC Bank.
Mr. Pathak, you're representing the bank?
Yes, he's representing.
How is this a writ?
Yes, that is one of the principal issues we have raised here.
I'll answer that issue.
No, I think first you should
No,
answer
I'll
that,
answer that
because
first.
if the respondent is HDFC Bank, then this court has a serious concern as regards the maintainability of this writ petition.
They have taken the issue of maintainability.
Rightly so.
My submission remains that they may be a private bank, but they are exercising a statutory power under a central act. Even a private person, because here, we are
Mr.
not
Ganguly,
concerned.
this court is not convinced of your argument.
Let me place the judgments on record.
HDFC Bank, there is no control of the center estate, nothing.
Not required.
It's a
Here we are not on the issue.
It's a purely private bank.
Admittedly,
how a writ is maintainable?
A writ would be
if you have an
maintainable.
authority, kindly show.
Lodge. Here, I am not pressing on the issue of Article 12. Here on the issue
No, how can you bring Article 12, Mr. Ganguly?
No.
Let us not unnecessarily invest more time. Give me the authority. If there is an authority, this court shall consider. Otherwise, I think it's a settled position of law. Yes. Which paragraph?
Lordship, I'll take your Lordship to page 1054, Malod.
Here, the respondent is an university.
It's a private university. It was a private university. I'll take your Lordship straight away to
University's position is sometimes different, because sometimes funds are received.
Yes.
And
Here
if there is a dominant control.
No, here in this university, Malod, there was no dominant.
Let us see.
Admittedly, it was
have you given a copy to the other
I
side?
do not have an extra copy by learned friend, but you can perhaps look it up. It's a well-known judgment.
Read out the citation for his benefit.
Yes, I've given. I'm ready to go.
Mr. Pathak, 2015 10 SCR 1049.
2010 SCR 1049.
Dr. Janit Jayapal versus SRM University. This is a decision from where?
This is a decision from the Supreme Court. So I'll take your lordship to para 5 on it. This is at page 1054. Lordship service.
You see, it is notified as a deemed university by the central government under Section 3 of the University Grants Commission Act.
Yes. No issue. That is there.
Deemed university, all the provisions of UGC Act are made applicable to R1, which inter alia provides for effective discharge of public function, namely education for the benefit of public. Once R1 is declared as deemed university whose all function and activities are governed by the UGC Act, alike other universities, then it is an authority within the article meaning of Article 12. Lastly, authority is within Article 12, then as a necessary consequence it becomes amenable to writ jurisdiction. Facts.
Facts are different, Malad, but the law, Malad, that is...
Facts are different, you admit?
Slightly different, Malad. Of course, Malad,
Mr.
every fact
Ganguly,
cannot be identical,
Mr.
Malad.
Ganguly,
If I may be allowed...
decision is contextual.
No issue, Malad. Here in the case, Malad, in Janet Jayapal's case, Malad, there was an issue of employer-employee relationship.
Very well.
Here, Malad,
HDFC Bank, let's get back to HDFC Bank.
HDFC Bank, Malad, is a private body. In this case, Malad, it is exercising a statutory power, Malad.
I think, Mr. Pathak, there is one decision of Standard Chartered Bank.
Yes.
And
then in Federal Bank of India, your lordship specifically said that even if a bank is performing a statutory function under an Act, the Act might govern how it is.
You have that decision.
Federal Bank, Malad, that decision is there. I think Sagar Thomas is referring to.
I don't know. You can also check, Mr. Ganguly. I think as Standard Chartered also is there.
Standard Chartered, I am not aware. I think Dharmendra Bohi or that is there.
Standard Chartered has aspects of the Right to Information Act also, your lordship, whether it is an authority under...
Here I would like to argue on a different point. Sagar Thomas, that Federal Bank decision, that was on the issue of an employee.
I am here to hear you, but only thing
it
appears it's a very short issue. Correct. So unnecessarily let us not travel too far also, because these are settled issues.
Because I will only stick to Janet Jayapal and what was argued by Mr. Salve in this case.
All right, let me hear you first.
If I may take your lordship to my lord's para 6 at page 105.
1055. Para 6. Yes.
We record our
Mr. Salve's arguments.
Yes, he was appointed as amicus.
Yes,
please. We record our deep sense of appreciation for the valuable assistance rendered by Mr. Harish Salve with the
usual fairness. You are adopting the same arguments.
Yes, Malad, because there is a twofold test here, Malad, which is very important. With his usual fairness and industry, and also for submitting his written note on the conclusion of the case on our request, submissions of Mr. Harish Salve were manifold. According to him, while deciding the question as to whether the writ lies under Article 226 of the Constitution of India, against any person, juristic body, organization, authority, etc., the test is to examine in the first instance the object and purpose for which such body, authority, organization is formed. So also the activity which it undertakes to fulfill the said object or purpose. Pointing out from various well-known English commentaries such as so-and-so, so-and-so, and especially, Malad, in the 6th line, what you will find, the decision in Andimukta Sadguru's case, Malad, and Z Telephone versus Union of India, Mr. Salve submitted that perusal of these authorities and decisions would go to show that there has been a consistent view of all the learned authors and the courts all over the world, including in India, that the approach of the court while deciding such issue is always to test as to whether the concerned body is formed for discharging any public function or public duty. And if so, whether it is actually engaged in any public function or performing any such duty.
All right, now you come to the finding of the court.
Lordship. I'll just take your lordship to two more paragraphs, 9 and 10.
That's all right. You see, these are the arguments.
Lordship.
What is the finding?
The finding,
court have understood the facts on the basis
yes,
of...
Lordship will come to my lord's page 1057.
Yes.
Para 14 onwards. Having heard learned counsel for the parties and on perusal of the
Para 15.
To examine the question urged, it is apposite to take note of what D. Smith, a well-known treatise on the subject, judicial review. The courts have adopted, the next para, two complementary approaches to determining whether a function falls within the ambit of the supervisory jurisdiction. First, the court considers the legal source of the power exercised by the impugned decision maker in identifying the classes of case in which judicial review is available. The courts place considerable importance on the source of legal authority exercised by the defendant public authority. Secondly, and additionally, where the source of power approach does not yield a clear or satisfactory outcome, the court may consider the characteristics of the function being performed. This has enabled the courts to extend the reach of the supervisory jurisdiction to some activities of non-statutory bodies such as self-regulatory organizations. We begin by first looking at the first approach based on the source of power. The previous section considered susceptibility to judicial review based on the source of the power, statute or prerogative. The courts came to recognize that an approach based solely on the source of the public authority's power was too restrictive. Since 1987, they have developed an additional approach to determining susceptibility based on the type of function performed by the decision maker. The public function approach is, since 2000, reflected in the Civil Procedure Rule so-and-so, defines a claim for judicial review as a claim to the lawfulness of a decision, action or failure to act in relation to the exercise of a public function. Similar to so-and-so, to define a public authority as any person certain of whose functions are functions of a public nature, but detailed consideration of that provision is postponed until later. As we noted at the outset, the term public is usually a synonym for governmental. Then, in para 17. In Andhi Mukta's case, the question before this court arose as to whether mandamus can be issued at the instance of an employee against a trust registered under the Bombay Public Trust Act, which was running an educational institution. The main legal objection of the trust while opposing the writ petition of the employee was that since a trust is not a statutory body, hence it cannot be subjected to the writ jurisdiction of the High Court. The High Court accepted the writ petition and issued mandamus, directing the trust to make payments towards the employee's claims of salary, provident fund and other dues. The trust appealed to this court. This court examined the legal issue in detail. Justice Shuansu, speaking for the bench, agreed with the view taken by the High Court and held this under. Next page, Manoj. Two questions, however, remain open for consideration: the liability of the appellants to pay compensation under ordinance so-and-so, the maintainability of the writ petition for mandamus as against the management of the college. The essence of the attack on the maintainability of the writ petition under Article 226 may now be examined. It is argued that the management of the college, being a trust registered under the Bombay Public Trust Act, is not amenable to the writ jurisdiction of the High Court. The contention, in other words, is that the trust is a private institution against which no writ of mandamus can be issued. In support of the contention, the council relied upon two decisions of this court: Executive Committee of Vash Degree College so-and-so and Deepak Kumar Biswas. In the first of the two cases, the respondent institution was a degree college managed by a registered cooperative society. A suit was filed against the college by the dismissed principal for reinstatement. It was contended that the Executive Committee of the college, which was registered under the Cooperative Societies Act and affiliated to the Agra University, was a statutory body. The importance of this contention lies in the fact that in such a case, reinstatement could be ordered if the dismissal is in violation of statutory obligation. But this court refused to accept the contention. It was observed that the management of the college was not a statutory body, since not created by or under a statute. It was emphasized that an institution which adopts certain statutory provisions will not become a statutory body, and the dismissed employee cannot enforce a contract of personal service against a non-statutory body. If the rights are purely of a private character, no mandamus can issue. If the management of the college is purely a private body with no public duty, mandamus will not lie. There are two exceptions to mandamus. These are two exceptions to mandamus. But once these are absent and when the party has no other equally convenient remedy, mandamus cannot be denied. It has to be appreciated that the appellant's trust was managing the affiliated college to which public money is paid as government aid. Public money paid as government aid plays a major role in the control, maintenance and working of educational institutions. The aided institutions, like government institutions, discharge public function by way of imparting education to students. They are subject to the rules and regulations of the affiliating university. Their activities are closely supervised by the university authorities. Employment in such institutions, therefore, is not devoid of any public character. So are the service conditions of the academic staff. When the university takes a decision regarding their pay scales, it will be binding on the management. The service conditions of the academic staff are therefore not purely of a private character. It has super-added protection by university decisions, creating a legal right-duty relationship between the staff and the management. When there is existence of this relationship, mandamus cannot be refused to the agreed party. The term authority used in Article 226 in the context must receive a liberal meaning, unlike the term in Article 12. Article 12 is relevant only for the purpose of enforcement of fundamental rights under Article 32. Article 226 confers powers on the High Courts to issue writs for enforcement of the fundamental rights as well as non-fundamental rights. The words any person or authority used in Article 226 are therefore not to be confined only to statutory authorities and instrumentalities of the state. They may cover any other person or body performing public duty. The form of the body concerned is not very much relevant. What is relevant is the nature of the duty imposed on the body. The duty must be judged in the light of positive obligation owed by the person or authority to the affected party. No matter by what means the duty is imposed, if a positive obligation exists, mandamus cannot be denied. Now, this issue was was again examined in great detail by the Constitution Bench in Z Telefilms versus Union of India, wherein the question which fell for consideration was whether the BCCI falls within the definition of state under Article 12 of the Constitution. This court approved the ratio laid down in Andhi Mukta's case, but on facts of the case held by majority that the BCCI does not fall within the purview of the term state. This court, however, laid down the principle of law in paras so-and-so as under. Be that as it may, it cannot be denied that the board does discharge some duties like the selection of an Indian cricket team, controlling the activities of the players and others involved in the game of cricket. These activities can be said to be akin to public duties or state functions. And if there is any violation of any...
All right, Mr. Ganguly, I've read it. Main paragraph is the 22.
Lordship.
Why, in what context at page 20, para 24
Yes.
it has been held to be made?
Yes. Now,
all right.
I am restricting myself to Article 226, not on because Article 12 has a restricted interpretation.
Yes.
My Lord, here in this case, my Lord,
Which is the paragraph of yours to justify that this writ is maintainable
Yes,
against
Lordship,
HDFC Bank?
my
What are the
Lords,
abovements?
I will rely, my Lords, from 17, my Lords.
Paragraph?
17.
Of your petition?
Paragraphs.
Yes.
Petition.
We have to apply the principles to your facts.
Yes, my Lord, no issue. And Lordship will also see for a minute, my Lord, what were the reliefs which were prayed for. At
All
the
right,
time
first come to your pleadings.
Lordship. Yes, Lordship will kindly have page 11, para 11.
Page 11?
Yes, of my writ petition.
Yes.
If I may read, that it may be pointed out, this part, that SARFAESI Act has been enacted by the Parliament under entry 45 of the Union list of the 7th schedule to the Constitution of India. On the other hand, the Registration Assam Amendment Act, which was passed by the state legislature introducing the section 21A to the Registration Act, has been passed under entry 6 of the list 3, concurrent list of the 7th schedule. It is a settled law that entry 45 of the Union list pertains to banking, which includes not only the activity of lending and borrowing of money, but also all activities related to recovery of
By
goods.
referring to SARFAESI Act, you are saying HDFC...
No, Lord, why I am saying, my Lord, when if Lordship sees the reliefs, what happened was that at that point of time, the sales certificates in the state of Assam required compulsory registration.
But you are not challenging any of the certificate issued by the SARFAESI Act. Your relief is against the HDFC Bank, correct?
Yes, yes. No, but also against the authorities. Lordship will, that's why, my Lord...
Who are the respondents?
Respondents are the state also, my Lord.
State is a respondent?
Yes, yes. State is a respondent.
And let's go to your relief then?
Yes, the relief, if I may point out, Your Lordship, that is at page 13, Lord.
Respondent number 4 is the HDFC
Respondent
Bank.
number 4 is the HDFC Bank, but respondent number 1, 2, 3 and 5, they are all the statements.
What is the relief from the
Because
state?
at that point of time, as I was submitting, my Lord, that the sales certificate is required to be mandatorily registered, my Lord. And when I approached the authorities concerned, they had put all sorts of conditions, like you get the NOC from the co-pattadars, this, that, your land is, because I have detailed everything in the writ petition, everything is there. So, I was facing a great difficulty. I have a sales certificate in my hand, which is nothing more than a piece of paper, my Lord. I went to all the authorities, and they said that neither we will register it because it is your land in the sales certificate is less than what this sales certificate is a defective one. And when I went to the municipal authorities, they said that you get an NOC from the co-pattadars. Lord, it is very difficult.
Yes, Mr. Pathak.
Lordship, if I may just...
See, Mr. Pathak, if this the relief was solely against the HDFC Bank, then of course this court would have been with you. But it appears that they are also aggrieved by the non-action of the respondents in issuing them the sales certificate.
The registration of the sales certificate.
In fact, if my learned friend is not pressing prayer number 1, then perhaps I cannot have anything to say, because that is the only...
You see, prayer number 1 and prayer number 2 are both connected.
Yes.
Right. Now, as regards, of course, this court is not going to issue a mandamus to the HDFC Bank. But as regards the prayer number 2, perhaps if a case is made out where this court finds that they are not giving it because he has a sales certificate in his name.
If I may just suggest something.
There also I will have, after my...
State is also there. Miss, who is appearing for state? Mr. Gogoi, you are appearing. Then why are you not issuing him the sales certificates?
No, my Lord. Sales certificate issued by them, my Lord.
They have to give you what?
My Lord,
register it.
My Lord, the issue here is that the sales certificate says, my Lord, 2 bighas, 2 bighas, 3 kathas, 9 lesas, my Lord. Whereas the actual land is, my Lord, 1 bigha.
Less.
1 bigha, 1 katha, 4.5
less.
the petitioner is willing to take, but they have to issue a fresh sale certificate with the
Unless and
amended portion
until
of
they
it.
have corrected the sale certificate, we cannot lose.
Correct, Malad.
We cannot
The
lose.
state here is correct.
I don't know how this writ is maintainable.
We cannot lose it.
So
Otherwise,
they cannot, unless that is done. The only thing that
you see, then
with the writ maintainable
Mr.
part, I have-
Ganguly, I'm sorry, but merely by putting a relief against the respondent when the respondent state cannot even do anything unless and until the HDFC Bank corrects it, then how this writ is maintainable? Because your whole grievance, everything is against the HDFC Bank.
No, part of the grievance is
And
also
if they
against.
are not amenable before under the 226
Here they
jurisdiction,
would be, here they would be, Manoj, because if I go, for example, let me take an example of if I go to the DRT, Manoj. The DRT, Manoj, cannot issue any instruction or direction to the state that you do this and that, Manoj. So, Manoj, the only remedy is before this court, Manoj. If my limited prayer is that, Manoj, they may correct the sale certificate, issue me a fresh sale certificate.
how do this court give that mandamus to the HDFC Bank?
Lordship will see.
That's a private bank.
Lordship will see, Manoj.
What show me under which provision the center or state has any financial control over the HDFC
Not
Bank?
needed, Malod. Even if it is a private body, Malod, Article 226 says any private body.
Your
exercising-
own decision shows
Lordship.
that in that case, that particular university, a lot of control was there.
Yes.
And that is the basis on which
If I may for a minute.
here
rely-
HDFC Bank, you show me in which paragraph you have said
Well,
how
Lordship-
they are amenable.
Oh yes, I have said in my
You are
rejoinder.
indicating to Sarfazi Act.
No, I am saying I have said in my rejoinder in reply to his affidavit.
Where? I'm
Yes.
asking you for that paragraph.
No, not in the writ petition, but in the rejoinder. Once they took the
You see,
application.
first hurdle that you need to cross is about
maintainable.
Yes. Once you pass that hurdle, then subsequent things will
As
come.
to what is the relevant
Correct.
document. Lordship, I have got you, Lordship. Lordship will kindly turn to my rejoinder at page 97 onwards, where I have replied to whatever they have stated.
97.
Lordship, the paragraph 4 onwards.
Yes, I have it.
Lordship, if I may read, Madam. That in reply to paragraph 4 of the affidavit so-and-so, the deponent denies that the writ petition filed by the petitioner is not maintainable before this honourable court as the respondent number 4 bank cannot be considered to be covered under the definition of state under Article 12 of the Constitution of India. It is submitted that the petitioner in the writ petition has prayed for a writ of or in the nature of mandamus against the official respondents to enable the registration of the sale certificate dated 25/3/2016 in favour of the writ petitioner. Such a writ is issued by this honourable court in its jurisdiction under Article 226 of the Constitution of India. Upon perusal of the provision of Article 226, it is clear that the writ can be issued to any person or authority, and it can be issued for the enforcement of any of the fundamental rights and for any purpose. Under
All right.
Article 226.
All right. Sorry, I'm cutting you short, but I've already read
Yeah,
it.
Lordship.
Anything else from your side?
My
I've understood
my
what you're
submission
trying to
remains
say.
that if the direction cannot go to them, that the sale certificate, Malod, then Malod, even then the sale certificate perhaps can be registered. In light of Malod, what I would like to place is one very short order of the Supreme Court, Malod.
Yes, please.
Pursuant to which, Malod, the Judicial Department of the State of Assam has made that the sale certificate, Malod, registration. Earlier it was, that is why the writ petition was filed below, because earlier there was 21A, Malod, of the Registration Act, the Assam Amendment. Now, pursuant to these orders passed by the Supreme Court, Malod,
What is this?
Now, Lordship will kindly come to this decision, Malod, of the Supreme Court.
Now, what was the issue involved?
Yes, the issue herein was that, Malod, whether the sale certificate issued by under the SARFAESI, Malod, whether it requires a mandatory registration. So, Malod, Lordship
How is
will,
it relevant here?
because, Malod, now it does not require mandatory registration. Malod, that is why
No,
the
but
due-
how is this decision relevant in the context of your case?
relevant because, Manoj, now the limited duty of the authorized officer of the banks is to issue the sale certificate and forward the copy to the sub-registrar.
No, but
Who will-
this issuing of issuance will not be done mechanically. They'll have to apply their mind.
I'm sorry, Manoj.
It cannot be done mechanically, isn't it?
No, the sale certificate, Manoj, when the sale certificate is issued, earlier the issue was that sale certificate has to be issued. And the government of Assam brought in section 21A of the Assam Amendment. That's why the argument regarding the Central Act, State Act, etc. Pursuant to these decisions of the Supreme Court, Malod, the Judicial Department of the State of Assam has examined the issue. I have placed that letter, Malod, in which, Malod, it has been said that the registration is now optional, not mandatory. My learned friend can
Have you
also...
given all this copy to the other side or not?
No, he can take my copy.
Huh? This court does not appreciate such passing
I'm fully
over
aware.
of pages
I'm fully
at the
aware.
time of hearing. You want to rely on something, kindly furnish to the other
Yes,
side
you
in
can take my
advance.
copy. Well, as far as the registration issue is concerned, now, my lord, that perhaps will not be a hurdle. The only issue is that, my lord, if the sales certificate, my lord, if the authority is ready to, my lord, accept that, then I have no case at all.
All right.
Yes. And as far as the relief, my lord, for the shortfall of land, that your lordship will give me liberty. I'll approach the forum concerned.
Yes, Mr. Gogoi. Should we hear you first or we hear the bank first?
Bank first, Lordship, yes, because otherwise, Lordship, if registration is not required, Lordship, then writ petition also, Lordship. No need to decide, yes, because Lordship.
Sorry, I am not clear.
If Lordship registration is not required as per this notification, as my brother has said, Lordship, if that be so, Lordship,
then the writ is not required.
Consideration of the writ petition is not required, Lordship.
Here there will be one.
Have you filed any affidavit in this
We have
matter?
not filed affidavit. Yes,
Because
basic,
you had said that you are not being able to do it because of something.
because of Lordship that part. That part I have
Because
because of Lordship the sale certificate shown there are land measuring land is Lordship 2 bighas so and so, but actual land is Lordship 1 bighas 3 quarters Lordship. It is there Lordship.
Mr. Pathak, I have still not clear. It's not clear to me exactly what the state has to do. But clear me that.
Yes, Lordship. As per the Assam Amendment, Your Lordship, whenever a sale on the basis of a sale.
Whenever?
As per the Assam Amendment of the Registration Act, on the basis of a sale certificate, when a sale has to be registered, that has to be done by the government. Now, what the government is saying is that since the land that is recorded in the sale certificate, the actual measurement is something else. So that is why they are refusing to register. And what the petitioner wants is he wants us to change the recording of the land in the sale certificate. Now, on merits, I have a case, Your Lordship, because there are documents to show that we have gone by what records were available with us, and the property was sold on as is various basis. But before going into that, Your Lordship, on the issue of maintainability, Your Lordship, that federal bank judgment, before taking Your Lordship through that, if I may just take Your Lordship through Ajay Hasiar, Your Lordship.
Yes, yes. That is one of the most.
Yes, the parameters of what constitutes state will just laid down, Your Lordship.
Yes,
Paragraph
please.
number 9, Your Lordship.
Para 9.
Para 9, Your Lordship. It starts as the tests for determining.
Yes.
Yes. The tests for determining as to when a corporation can be said to be an instrumentality or agency of government may now be culled out from the judgment in International Airport Authority case. These tests are not conclusive or clinching, but they are merely indica which have to be used with care and caution, because while stressing the necessity of a wide meaning to be placed on the expression other authorities, it must be realized that it should not be stretched so far as to bring in every autonomous body which has some nexus with the government within the sweep of the expression. A wide enlargement of the meaning must be tempered by a wise limitation. We may summarize the relevant tests gathered from decision in International Airport Authority case as follows. Number one thing is clear that if the entire share capital of the corporation is held by the government, it would go a long way towards indicating that the corporation is an instrumentality or agency of the government. We do not meet that.
So one of the requirements is that it has to be an instrumentality of the state.
Yes,
right.
The entire share capital has to be by the government. Then number 2, whether financial assistance of the state is so great as to meet almost entire expenditure of the corporation. It will afford some indication of the corporation being impregnated with governmental character. We don't fulfill that. Number 3, it may also be a relevant factor whether the corporation enjoys monopoly status which is state conferred or state protected. No.
What does this mean?
Your Lordship, for example, the BCCI matter, cricket, Your Lordship, otherwise regulation of sport is a state function. But the BCCI, though it is a society, was given the power to choose the Indian cricket team and represent
There was
India.
a state monopoly.
It's a state conferred monopoly, Your Lordship.
Okay.
Number 4, existence of deep and pervasive state control may afford an
That is
indication.
also not there.
That also we are not there. Number 5, if the functions of the corporation are of public importance and closely related to governmental functions, it would be a relevant factor in classifying the the corporation as an instrumentally or agency of
What
government.
does this mean?
If it is-
Closely related to governmental functions?
Yes.
Because otherwise, a function of a state does have some public importance, correct?
Yes,
Because
but-
they are dealing with public.
Lending money on interest and in recovery of such money, which is the issue here, that is definitely not a governmental function, Your Lordship. So in certain cases, Your Lordship, for example, under the RTI Act, the Supreme Court has held that certain functions of certain organizations, though they may not fulfill the state, but they may come under the purview of the RTI Act because those functions have a bearing on public importance. But here, the issue is that we are lending money on interest.
Bank is under what provision? It's
Under the Banking Regulation Act.
Under the Banking Regulation
Yes.
Act. And HDFC Bank is otherwise what? Is it a company?
It's a banking company.
It's a banking company.
Banking company.
And banking company is defined.
In the Banking Regulation Act, no, Your Lordship, it is not.
Where is it? Is there any
It is
definition?
otherwise, Your Lordship, I do not have the exact holding structure, but it is completely privately owned, Your Lordship.
No, see, I understand that. But
I'll
now,
just-
if I have to give
Yes, I'll ask my colleague to just get
judgment
that.
because
Yes.
so many things have come, I'll have to deal with it.
I'll just
so
ask my
for
col-
that, I will also have to see, correct?
Yes, sir.
As
I'll ask my colleague
regards-
to get it. Lordship, I'll get it in 5 minutes time. I'll ask
Yes.
my colleague to get it.
Absolutely. All right, I'll come in.
Yes.
Come back in 5 minutes. Try to see if you can get hold of the banking. What is a banking
Yes, yes,
company under
yes.
what regulations?
Yes.
Just to see.
Yes. Lordship, the relevant definitions are at sections 5B and C of the Banking Regulation Act. Your Lordship.
Section
5, subsection B and subsection C of the Banking Regulation Act.
subsection B and C.
Yes, Your Lordship.
Banking Regulation Act.
Yes, Your Lordship. 19.
Yes, please.
In this act, unless there is anything repugnant in the subject or context, banking means the accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, and withdrawable by check, draft, order or otherwise. And C, banking company means any company which transacts the business of banking. So this is the principal act which governs the activities of all public and private sector banks in India, Your Lordship,
So here there is a statutory regulation,
which regulates our functioning.
the functioning of the bank.
Yes, Your Lordship. And similarly, the SARFAESI Act, Your Lordship, its objectives make it clear that it is, if I may take Your Lordship to the SARFAESI Act.
Yes.
The objectives of the, I'll just read it out, Your Lordship. The objective of the SARFAESI Act is,
To regulate securitization and reconstruction of financial assets.
yeah, it says, acting on the suggestions of so and so, these SARFAESI Act Ordinance of 2002, which later became the Act.
Where are you reading from?
I'm reading from the objectives of the Act, Your Lordship.
Okay, okay.
Yes,
Okay.
it's on the second page, page
Yes.
number 2.
Yes.
Uh,
Yes, I've got it.
the sentence starting as acting on these suggestions, the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Ordinance 2002 was promulgated on 21st June 2002 to regulate securitization and reconstruction of financial assets and enforcement of security interest and for matters connected therewith or incidental thereto. The provisions of the ordinance would enable banks and financial institutions to realize long-term assets, manage problems of liquidity, asset liability mismatches, and improve recovery by exercising powers to take possession of securities, sell them and reduce non-performing assets by adopting measures for recovery or reconstruction. So that test of Ajay Hasia that this is not a public function, Your Lordship, because this is a lending money on interest, Your Lordship. It is a purely commercial function which the banks do, though it is regulated by an act because everything has to be regulated, but it is not a governmental function which has been delegated to the banks, Your Lordship.
That last condition of Ajay Hasia, what was that?
Yes, Your Lordship.
related to government functions.
Government functions. This is not a government function, Your Lordship. Regulation is. Regulation of a bank. So, for example, the RBI, Your Lordship, would definitely be under the state because it regulates the functioning of other banks.
Perhaps it will be more clear when we read that decision which is on in context of a bank.
In federal bank, yes. So RBI would be a public authority since it regulates banks. So it's
But
performing
here
a
actions of RBI is not under
not
challenge.
under challenge. We are just a bank. And number 6, Your Lordship, it relates to corporations, Your Lordship. Perhaps that would not have any application in this case.
All right.
Now, in the federal bank judgment, Your Lordship, a copy which is there.
Yes, I have.
Yes. The relevant paragraphs are 28, 29 onwards, Your Lordship. I will just read them out. The issue was regarding service conditions of employees, Your Lordship, but the findings are, Your Lordship, perhaps critical. Para 28, Your Lordship. It starts at page 756.
Here, in the present facts, HDFC Bank had auction sailed a particular plot of land.
Yes, Your Lordship.
Perhaps a defaulters
For a default.
for a default,
Yes.
right? So, and
He is the successful.
he is the successful auction purchaser.
Yes, Your Lordship.
Now you see, Mr. Pathak,
Lordship.
this you may not. I am only expressing my mind right now. I don't know what I will ultimately hold. But this function, if you see, it's not purely private because this is not relating to banking activities as such. You have called for an auction.
Yes, Your Lordship.
You've discharged a public function where you have sold the defaulted land through an auction, correct?
Lordship.
Now here you owe a duty to the public. Now according to them, the land that have been sold to them.
Lordship, would that be a duty to the... I'm just thinking out aloud. Would
Yes,
that
yes.
be a duty to the public or a duty to us, Your Lordship, to recover a bad loan in terms of the guidelines, in terms of the procedure
Correct.
laid down
But
in the
you
Act?
see, in that, in order to recover that money, ultimately you have called for auction.
Auction.
Right? Where
Yes,
they
sir.
have participated.
It's a public auction.
It's a public auction
Lordship.
where they have participated.
Yes, Your Lordship.
And in pursuant to that participation, you have selected them.
Yes.
Thereafter, you have given them this land.
Yes.
Now, in that certificate, there is some error as regards the
Yes, that
land.
is another...
Whatever.
Yes, yes.
But it appears there is some error
Yes.
as regards the quantum of the land,
Lordship.
for which they are not being able to register.
Lordship. Lordship.
Think it loud,
Yes.
because before going further, it
Yes.
appears, because this is not something purely banking transaction.
But would that fulfill the test of a public function?
That is exactly what this court will now have to decide.
Lordship.
That is why I'm putting it across to
Lordship,
you for
but,
assistance. Now,
my
whether because
understand-
of that,
Yes.
one can say that they qualify that can it will be amenable. This particular function of yours shall be amenable under 226.
I mean, from the objectives of the ordinance, from the Act, it appears, Your Lordship, the Act was enacted to lay down a mechanism for recovery of debts, Your Lordship. The giving of loans and recovery is definitely a banking function. It is a purely banking function. Now we are dealing with the process of recovery here. So this Act, Your Lordship, it only lays down the procedure. Now, if I put it in another way, Your Lordship, if this Act was not there and somebody had created a mortgage with us and then pursuant, without resorting to the provisions of this Act, Your Lordship, we had enforced that mortgage and sold it off through a usual process of auction, Your Lordship. Maybe through a private auction without dealing with the public at large, Your Lordship. Even then, it would be something which is directly correlated to our banking functions, banking activities, Your Lordship, of
That
the
you're
recovery
right.
of a loan. All this Act does, Your Lordship, in my understanding, is lay down a mechanism a strict mechanism
for recovery.
For recovery of a loan which is a banking function.
All right, let's
Right.
see these
Yes.
paragraphs.
Paragraph 28 on.
Just one second. Varsha, you go and we'll call when you want, when we need you. We'll call you when we need you. Yes, Mr. Pathak.
Yes. Para 28 onwards, Your Lordship. There are the 6 factors which have been enumerated in the case of Ajay Hasia and approved in later decisions in the case of Ramanna and 7-judge bench in the case of Pradeep Kumar Viswas may be applied to the facts of the present case and see whether those tests apply to the appellant bank or not. As indicated earlier, share capital of the appellant bank is not held at all by the government, nor is any financial assistance provided by the state. Nothing to say which may meet almost the entire expenditure of the company. The third factor is also not answered, since the appellant bank does not enjoy any monopoly status, nor can be said to be an institution having state protection. So far as control over the affairs of the appellant bank is concerned, they are managed by the board of directors elected by its shareholders. No governmental agency or officer is connected with the affairs of the appellant bank, nor is any one of them a member of the board of directors. In the normal functioning of the private banking company, there is no participation or interference of the state or its authorities. The statutes have been framed. This is perhaps will have some relevance.
Yes.
The statutes have been framed regulating the financial and commercial activities so that fiscal equilibrium may be kept maintained and not get disturbed by the malfunctioning of such companies or institutions involved in the business of banking. These are regulatory measures for the purpose of maintaining a healthy economic atmosphere in the country. Such regulatory measures are provided for other companies also, as well the industries manufacturing goods of importance. Otherwise, these are purely private commercial activities. It deserves to be noted that it hardly makes any difference that such supervisory vigilance is kept by the Reserve Bank of India under a statute or the central government. Even if it was with the central government in place of the Reserve Bank of India, it would not have made any difference. Therefore, the argument based on the decision of All India Bank Employees Association does not advance the case of the respondent. It is only in case of malfunctioning of the company that occasion to exercise such powers arises to protect the interests of the depositors, shareholders, or the company itself, or to help the company to be out of the woods. In times of normal functioning, such occasions do not arise except for routine inspections, etc., with a view to see that things are moved smoothly in keeping with fiscal policy in general. There are a number of such companies carrying on the profession of banking. There is nothing which can be said to be close to the governmental functions. It is an old profession in one form or the other, carried on by individuals or by a group of them. Losses incurred in the business are theirs as well as the profits. Any business or commercial activity may be banking, manufacturing units, or related to any other kind of business generating resources, employment, production, and resulting in circulation of money are no doubt such which do have an impact on the economy of the country in general, but such activities cannot be classified as one falling in the category of discharging duties or functions of a public nature.
You see, this is exactly what in the initial.
Yes.
This court has also made it clear.
Yes, Your Lordship.
I am of the same view.
Lordship.
But only thing, that part I was wondering whether
it can
yes,
relate to the SARFAESI also.
Correct, because you see, with times inroads are being made.
Yes.
Initially it was very conservative, right? It has to be a
Yes,
state,
of course.
everything. Now a lot of other organizations, corporations, universities are brought in.
Yes.
And in order, not generally the veil is lifted to see who is under the control, where the funds are coming.
Universities, perhaps they form a class apart because
obviously because they
education,
have a
Your
grant.
Lordship, is.
Yes, there are a lot of things. There is a control. There
Yes.
is a grant.
Yes.
Now, if those factors are there, undoubtedly.
And education, Your Lordship, perhaps it can be said to be a it can be said to be a public function because one of the responsibilities of a government is to educate the populace, people, Your Lordship.
Directive principles.
It is, Your Lordship. But giving money on interest, Your Lordship, and then recovery, perhaps that has nothing to do with.
No, in fact, this decision is in your support,
Yes, Your Lordship.
it is clarifying because
Yes.
this is in the context of a bank.
Yes, Your Lordship. It is in the
Correct?
context of a bank.
The queries that this court was putting to you, I think, are by and large
Yes.
coming out from the
Yes.
ratio of this decision.
Para 32 and 33 once, Your Lordship. I'll just not read the rest of it. It's more of
Yes.
Para 32, Your Lordship. Because otherwise it has only, what has fallen from Your Lordship, that has been reiterated. Since even though it might be regulated, the function, banking function as a whole cannot be said to be a public function of the government. Para 32 for once, Your Lordship. Merely because the Reserve Bank of India lays the banking policy in the interest of the banking system or in the interest of monetary stability or sound economic growth, having due regard to the interests of the depositors, etc., as provided under Section 5CA of the Banking Regulation Act, does not mean that private companies carrying on the business of commercial activity or banking discharge any public function or public duty. These are all this perhaps would have some bearing. These
Yes.
are all regulatory measures applicable to those carrying on commercial activity in banking, and these companies are to act according to these provisions, failing which certain consequences flow as indicated in the Act itself. As to the provision regarding acquisition of a banking company by the government, it may be pointed out that any private property can be acquired by the government in public interest. It is now a judicially accepted norm that private interest has to give way to public interest. If a private property is acquired in public interest, it does not mean that the party whose property is acquired is performing or discharging any function or duty of public character, though it would be so for the acquiring authority. Para 33. From the discussion held
This
above.
is absolutely clear now. 33.
Yes. From the discussion held above, in our view, a private company carrying on business, banking business as a scheduled bank cannot be termed as an institution or a company carrying on any statutory or public duty. A private body or a person
This
may...
has clarified.
Yes, Your Lordship. And relying on this, Your Lordship, Allahabad High Court has in the case of HDFC Bank held that it is not a...
You have it?
Yes, Your Lordship. This is from the High Court of Allahabad by division bench.
Ayurveda blinders to the bosom. This relied on
Federal Bank.
Federal Bank.
Yes, Your Lordship. Para 3, Your Lordship. The name of this is by division bench. Kailashi Devi versus branch manager and another.
Yes.
Para 3. At the outset, learned counsel for the respondent bank has raised a preliminary objection that the present writ petition is not maintainable as HDFC Bank is a private bank not covered within the...
All right. Para 6.
Yes. Then Para 6, Your Lordship. Following the law laid down by the Honourable Supreme Court in the above decision that the private financial institutions carrying of business or commercial activity...
Very well. This is clear.
Yes.
Now, you see, because in your petition,
yes, sir.
In the present case, they have combined two reliefs.
Two reliefs.
So you address that issue now.
Yes. Now, this is strictly on merits, Your Lordship.
Correct.
Yes. Now,
strictly on merit.
Because
this
strictly
is
on merit.
On maintainability.
Because on
what you have submitted right now is on maintainability.
Yes, Your Lordship.
Yes.
I mean, what I am going to submit now would be on the merits of his claim, Your Lordship.
Not exactly.
I have not submitted on merits at all.
Correct.
Very well, Your Lordship. Then, on regarding
Mr.
that,
Pathak,
regarding the clubbing of...
You see, because if it was relief A alone,
yes,
there is no doubt absolutely
yes, Your Lordship,
in the minds of this court that this writ petition is not maintainable against HDFC Bank.
Very well, yes.
Following the ratio of Federal Bank,
yes,
which is rightly
yes,
held by the Allahabad Division Bench, and this court has no reasons to differ from the views taken by the Division Bench of Allahabad Bank in a case relating to HDFC Bank.
Lordship.
All right. Here, in the present case, they have also another relief, where the functions of the state is involved.
Yes.
Now, whether by clubbing that, they are can it be said that this writ is maintainable? Please address that issue.
Lordship, from what I have understood...
And if you have stated something in your affidavit...
Our affidavit is limited to what binds us or what prohibits us from issuing that certificate or correcting it now.
All right.
But on this aspect, Your Lordship, what has fallen or what is the projected case in the petition is that because of the provisions of the Assam Amendment to the Registration Act, the state is bound to give them a permission, and only then the sale can be registered. Now, due to certain, without going into the merits, due to certain restrictions faced by us, Your Lordship, that is the certificate that can be issued by us at this point, without correction of some other records. Now, if without touching that sale certificate, permission can be granted by the state, Your Lordship, and without, because the rules are not under challenge, then perhaps some relief can be granted.
Because in that case, non-action will will come in arbitrary.
I cannot.
But here the state cannot do anything unless and until you correct. This is the stand of the state.
Yes, Your Lordship.
Given that circumstances, the writ perhaps is not maintainable because here actual relief is against you.
Yes, Your Lordship.
Unless and until you do your part, state cannot. That's a consequence.
Yes, Your Lordship.
That part has not come.
Yes, Your Lordship.
Isn't it?
Yes, Your Lordship.
So therefore, non-action of the state merely stating will not make this amenable under writ jurisdiction. This is what your sum and substance of the argument?
Precisely. And why we could not do so, I'll reserve, after what my learned friend submits, I'll...
Yes, why you cannot?
Perhaps my
let me hear you first. Why you cannot?
Now, Your Lordship, when
in just short, I just want to understand.
When the property was mortgaged to us, a mutation certificate was given along with the patta. On the basis of those documents, Your Lordship, an equitable mortgage was created. It was auctioned on the basis of the same documents, with the description of the property as contained in those documents. It was in the auction notice, the petitioner was supposed to exercise due diligence, which he has done. After everything was complete, only at the stage of registration he has come up and raised an objection that no, this is not what the actual measurement of the property is, this is. And the foundation of his claim is an internal opinion of a valuer. Now, as per the provisions of the... Very good. Until those documents are corrected, Your Lordship, because of the provisions of the Assam land revenue regulations, we would not be able to correct the sale certificate.
What does the prayer number 2 means, Mr. Ganguly?
Thank you.
Number 2.
Yes, at that point of time, as I had submitted,
there was a requirement.
There was a requirement.
Now this is not there.
Though it is still on the statute book, but going by that clarification.
So this is gone.
This is, my lord, not gone because registration, my lord, still is my right. Registration is still there.
But that certificate, something that you had given, what was that?
Because there are decisions of this court I can place on record, where if the auction purchaser, my lord,
you just
insists,
gave us something, right?
Yes, that opinion of the judicial department. Of
Correct.
State of Assam.
As per this, what does this say?
Well,
requirement of registration?
Yes, requirement of
does
registration
not require.
Is optional, but earlier.
So then your prayer number 2 has become infractious.
No, my lord, registration is optional. But if I want to get my...
But you see, if it is optional, you cannot make that, you cannot have a grievance key, no, they are not doing it because this letter itself which you have given indicates that I'm directed to clarify the issue regarding registration of sale certificate as per section 17(2)(12) of the so-and-so Act for the completion of the sale pursuant under the scheme of SURFACE does not require registration of a sale certificate granted to any purchaser of any property sold so-and-so by so-and-so.
Yes. Now,
clarifies then.
Now, my lords, if the sale certificate as it stands today, my lords, is registered, let us say for example if it is optionally registered, even then, my lord, the sale certificate will be a defective one because the registration cannot be done of a defective sale certificate, nor my name will be mutated in the Jamabandi or in the revenue record in respect of the entire 2 bighas whatever was sold in the auction. Right. And so, my lord, this is a clarificatory thing which is there. And your lordship will see.
Alright, I am fixing this matter tomorrow at 2. I'm taking it that the arguments are complete.
My side is not complete.
You still have something to say?
I have
yes,
because I
please
have not
complete
submitted
then.
on merits. Well,
All right. No, I'm not hearing on merits.
On merits even I have not.
I'm not hearing. I'm confining myself only on the
maintainability. Lordship, then I'll complete today on
yes,
the
please complete. What more you have to complete?
Lordship,
Mr. Pathak has replied to your argument.
Mr.
In
Pathak
reply
has
to
relied
that,
on
you want to say
every
something?
judgment that is relied on, my lords, does not involve any statutory function. Lordship will kindly have para 33 again of Sagar Thomas, my lord. I have myself relied on that judgment in a number of decisions. Lordship will come to para 33 again.
Para?
33. Every judgment turns on the facts your lordship has observed, my lord.
Yes.
Lords, if I may read again.
Yes.
For the discussion held above, in our view, a private company carrying on banking business as a scheduled bank.
Para 33 of which judgment?
Yeah, 33, which my friend started reading.
No, federal.
Federal, yes.
One second. Yes, please.
For the discussion held above, in our view, a private company carrying on banking business as a scheduled bank cannot be termed as an institution or a company carrying on any statutory or public duty. A private body or a person may be amenable to writ jurisdiction only where it may become necessary to compel such body or association to enforce any statutory obligations, or such obligations of public nature casting positive obligation upon it. We don't find such conditions are fulfilled in respect of a private company carrying on a commercial activity of banking. Merely regulatory provisions to ensure such activity carried on by private bodies work within a discipline do not confer any such status upon the company nor puts any such obligation upon it, which may be enforced through issue of a writ under Article 226 of the Constitution. Present is a case of disciplinary action being taken against its employee by the appellant bank. The respondent's service with the bank stands terminated. The action of the bank was challenged by the respondent by filing a writ petition under Article 226 of the Constitution of India. The respondent is not trying to enforce any statutory duty on the part of the bank. That being the position, the appeal deserves to be allowed. The statutory duty, I am saying, that is my case. Under Rule 9 of the SARFAESI rules of 2002, there is a statutory duty. You will deliver the property to me free of encumbrances and issue a sale certificate. Then only the sale is complete. Lord, can a public auction be held? Lordship will see page 50 of the writ petition. Their own valuer is saying 1 bigha, 1 kata, 4.5 lesas. And 4 months later, they put in an auction saying, no, 2 bigha, 3 kata. Malad, what is this going on, Malad? Public auction is a public auction.
All right, next.
Malad, this is, Lordship will kindly have the Rule 9 Malad, for a minute of the security interest rules. Rule 9. Security Interest Enforcement Rules 2002.
Yes.
Lordship will come to Rule 9.
Time of sale.
Time of sale, issue of sale certificate, delivery or possession. These rules are also framed by the central government under the SARFAESI Act. Section 38 of the Act provides. Lordship will kindly have Rule 6 onwards, if I may read.
Rule 6?
Yeah, Sub-Rule 6. Rule 9, Sub-Rule 6. On confirmation. This
yes.
Part. On confirmation of sale by the secured creditor and if the terms of payment have been complied with, the authorized officer exercising the power of sale shall issue a certificate of sale of the immovable property in favor of the purchaser in the form given in Appendix 5 to these rules. 7. Where the immovable property sold is subject to any encumbrances, the authorized officer may, if he thinks fit, allow the purchaser to deposit with him the money required to discharge the encumbrances and any interest due thereon together with such additional amount that may be sufficient to meet the contingencies or further cost, expenses and interest as may be determined by him. Provided that if after meeting the cost of removing encumbrances and contingencies there is any surplus available out of the money deposited by the purchaser, such surplus shall be paid to the purchaser within 15 days from the date of finalization of the sale. 8. On such deposit of money for discharge of the encumbrances, the authorized officer shall issue or cause the purchaser to issue notices to the persons interested in or entitled to the money deposited with him.
Understood.
9. The authorized officer shall deliver the property to the purchaser free from encumbrances.
And that procedure is given in the rules.
Lordship. And Lordship will now come to, because the merit has to be little seen, page 50, You will get your opportunity, don't you? This is the valuation report which their own valuer has prepared. Lordship will kindly come
I'm
to
not
page.
going into the merit right now.
Lordship will have to deal with it a little bit because it is connected with the violation of the statutory duty. Page 51, my lords. Report is dated 12th of June 2015. Page 51. And Lordship will find, my lords, that the bottom.
Page 51.
Area of the unit. Yes, page 51.
Yes.
Area of the unit, the column 12 on the same page, bottom. Page 51.
Yes, yes, 1 bigha.
1 bigha, 1 katha.
This is given by their value.
This is given by their value. Their valuation report, and this is dated.
This is the reason why that error has come.
No, this is the correct measurement of the land.
This is the correct measurement.
Yes, my lord. And now lordship
And in your sales certificate?
Sales certificate also same. No, sales certificate, my lord, they have given 2
Where is
bigha.
that?
Yes, that is there, my lord, at page 20.
Where? Page?
Page 20, my lord.
Why don't you correct this and finish this matter?
Well, unnecessarily they are dragging my lords for that.
If my learned friend perhaps will get agitated if I interrupt
No, I'm
him.
not agitated by anything.
He will not get agitated, but
no, there is
generally
a
what
lot-
happens,
Facts
it
of the
creates
case.
difficulty when you hear in piecemeal manner. Sometimes you get...
Yes. No,
it breaks the flow.
It was in a
But
lighter vein.
since, the court is posing the question, you can always answer.
It was in a lighter vein. There was nothing like that. Lordship,
Page 20 is otherwise the same.
yes, the issue is under the Assam Land Revenue Regulations, Your Lordship. Judgment it out.
No, but here apparently on the face
Yes.
of it looks this is wrong.
This is a valuation report of an internal valuer, Your Lordship. Now, Your Lordship will kindly have a look at the mutation certificate.
Page 20, Mr. Ganguly.
Yes, page 20 is my sales certificate, my lord. That they have
Where
issued.
is that measurement of the land
Yes,
given?
measurement of the land, my lords, is at page 22, my lords. The schedule which is signed by the authorized officer. Page 22. The
Where-
property.
where is
My lord,
the
description of the
2 bighas,
unit,
3
2
katha?
bighas, 3 kathas, 9 lectures.
Yes.
Yes. This is the sales certificate.
Now what is this?
Just to
One
finish the
second.
point. Page 19 also, my lord, the auction notice.
In auction, how, the
Yes.
measurement is given.
Yes, the auction, the measurement, my lord, there. Performance has
Yes,
to be
please
given, my lord.
point
This is
out.
also dated, my lord, column
Where,
number,
where?
column number 3, my lord.
Where is it given?
My lord, the column, the third, my lord, row. Lordship will find the third.
Yes. 2 bigha.
3 kathas and 9 lechas.
Manifestly seems to be.
I'll show Your Lordship, Your Lordship. From those two documents,
You
it
see,
appears.
Mr. Pathak, this is your auction sale notice.
Yes.
Your valuer's notice.
Valuers, Your
Then-
Lordship. Why we could not rely on the valuers report and rather had to rely on the revenue records, Your Lordship?
No, but your own auction sale notice.
My auction sale notice is based on the revenue records, Your Lordship.
You have given it.
Yes, Your Lordship. On the basis of.
You have given it for 2 bigha, 3 katha.
Yes, Your Lordship.
And then ultimately you are giving him only 1 bigha.
No. His sales certificate. Lordship may have a look at the sales certificate. The sales certificate is at page number 20.
Yes.
It is for the exact
2 bigha.
Yes, Your Lordship.
The valuers is 1 bigha.
Valuers is 1 bigha. What has happened in this case, Your Lordship? The revenue record says 2 bigha, 3 katha, no lesser. 2 bigha, 3 katha, 9 lesser. On the basis of those revenue records, Your Lordship, we have proceeded with the auction sale.
According to you, it is 2 bigha.
According to us, it is 2 bigha, 3 katha, 9 lecha because that is what the revenue records say. And on the basis of those revenue records, we have proceeded with the auction sale. During the tender, during the auction, when he participated, he inspected those records. In fact, he has signed that I have inspected the records and I know that it is what it is, and he has indemnified us. Now, he wants us to, without correcting the original revenue records, he wants us to correct the sales certificate. If we do that, hypothetically, what happens? Then the original borrower will come and say, I mortgaged 2 bighas, 3 kathas, 9 lessas, and you have only sold 1 bigha.
Alright.
Then,
anyway, I'm not getting into that. I just wanted to get a grip of the
now because
of this particular fact.
Unless those records
what
are corrected,
what
Your
has
Lordship.
been wrongly recorded. I don't want. First, this court will decide whether
Very well.
226 lies or not. If it comes to a conclusion that it's maintainable, then further opportunities will be given to both sides.
Look, one last submission, my lord.
Yes, our value.
Yes.
This was before the auction, 4 months prior
See,
to the
Mr.
auction.
Gogoi, the question that this court is posing is about the maintainability of a rate. Yes. Now, because you see, you are also not helping. In the sense, I'm not saying you, but the state. Because suppose the state, after seeing this, would have corrected, one could have understood. You have not taken a stand also. But here, during arguments, you've said that you cannot do anything until and unless HDFC Bank does the correction. This is your stand, right? Now, in that situation, it appears that if a mandamus is issued, will have to be issued to the bank. Now, whether that lies or not, that becomes the primary question. Because only if the answer is yes, then you may come in picture. Now, merely because a relief is sought against you, where you cannot at this stage do anything, perhaps it will be of no consequence.
One aspect, the
Correct.
revenue records, in fact the mutation certificate issued by the circle officer, he has said that it is 2 bighas, 3 kathas, 9 lechas. Now under regulation 40,
Where do you get that?
That is at page number 38, Your Lordship, of the petition.
Circle officer's report.
Yes, Your Lordship.
38?
It's a certificate of mutation.
But you see,
Now, under
I
regulation,
don't think it is
2006, madam.
It's the domain
Auction
of this
16.
court to get into all this.
Yes.
Whether it's 2 bigha or 1
No,
bigha.
why-
This is for
what my
the
learned friend is
correct
effectively-
authorities to inquire and find out.
now for a correction of this record, there is a now for correction of this record, there is a detailed procedure of before the circle settlement officer and then before the revenue board laid down under the regulations. Now, without exploring that,
there is a procedure laid
because
down?
this is a revenue record under regulation 40, Your Lordship. This record, Your Lordship, until it is proved to be wrong.
Where is that?
I have Assam land revenue regulations. Judgment to the Assam land and revenue regulations of 1886, Your Lordship.
I don't think you have a copy. Do you have that book?
This book. That was.
Asa?
Land Review 1886. Land Revenue
Assam
Regulations
land
1886.
1886.
These decisions are for correction.
Lordship.
What are these decisions?
Yes, these decisions are, Your Lordship, to show. I'm just going to give them. To show, Your Lordship. I did not want to get into the merits today, Your Lordship. These decisions are to show that until it is proved that those records are wrong, they have to be presumed to be correct, Your Lordship. And
by giving me all this, you'll be only delaying the court for giving the judgment.
I do not want to
this court more.
I do not want to go into
I
that.
think I've made it very clear
Very-
that
yes,
I'm confining myself first
Very well, Your Lordship.
to this jurisdiction.
Very well, Your Lordship.
Because if I find I have no jurisdiction, why should I enter into
Very
all
well,
this?
Your Lordship. No, I am just.
Why will permit me then tomorrow to submit that because the
Submit more what?
No, only judgment.
On?
My lord, the issue is
On
that
which judgment?
a writ petition on the issue of maintainability.
You've already
cannot be-
submitted, Mr.
No,
Ganguly.
Lordship will permit me. Cannot be rejected in part. Just as a claim under order rules 711 cannot be rejected in part. A writ petition cannot be rejected in part.
I'm not going to
Because
reject
my lord,
it
my
in
reliefs
part.
are qua him also and against him also.
Very
Lordship
well.
will consider that. And all the judgments my learned friend has relied upon, no non-statutory.
Hearing remains inconclusive. List on আমাৰ মঙ্গলবাৰ দুটা বজাত কিবা আছে Wednesday আছে Wednesday. I'm fixing it on Wednesday at 2.
Lordship.
Mr. Ganguly, in case you get hold of a judgment, only that you will be placing it on at 2 o'clock on Wednesday. No further arguments as regards this jurisdiction. I'm making it very clear. I have
fixing
heard
it
you
for
all
order on
for quite at length. I don't think you can have any grievance on that.
No, on Wednesday, Lordship is fixing it for orders on maintainability or...
I'm fixing it, but with the understanding I'm passing the order on that. However,
deeply
in case
obliged.
you get hold of a decision, you can give it to me on that. But no further.
By tomorrow, I'll try to give.
Yes, you can give it to the court master.
Deeply obliged.
Yes.
Obliged.
Mr. Pathak, can you just mark that provision? You said there is a provision for correction. Only that. In the Assam Land Revenue.
There is a provision for appeal. If you are not
Appeal,
satisfied.
yes.
I'll just mark.
এইকেইটা সব থৈ দিব দেই part third, okay? Yes.
Handling item number 16.
Let's call for the CD.
CD receipt. 16?
16.
CD receipt?
CD receipt, last occasion the CD was there, but the statement of the
This is the AB?
AB. AB.
161 statement you have?
Yes. 82.
Yes. Any implication?
His statement, he himself admitted. He is also a police officer.
After, in terms of the order passed by this court, he has appeared before the IO and has his statement has been recorded.
Yes.
In which he admits.
Yes.
Now he is participating.
He is participating.
So I shall make it absolute then. He has already given his statement.
Yes, my lord.
Isn't it?
Guard, my lord.
Yes. Heard Mr. S. Bora, Learned Counsel for the petitioner. Stop. Also heard Mr.
BB Gogoi.
BB, right?
BB Gogoi.
BB Gogoi, Learned APP for the state. Learned APP for the state respondent. Stop. This is an application under section 438 of CRPC 1973 seeking anticipatory bail to the accused petitioner I. Bhuben Chandra Das, who is apprehending arrest in connection with Patsala PS case number 15/2024 registered under sections 120B, 409, 468, 471 of IPC. Stop. Pertinent that, before that, the case diary called for is placed before the court. Pertinent that by order dated 10/4/2024, the petitioner was granted the privilege of interim pre-arrest bail with the subject to condition thereof. Stop. Mr. BB Gogoi, Learned APP, submits that the petitioner has appeared before the investigating officer in terms of the order passed earlier by this court. Stop. He further submits that the statement of the petitioner has been recorded under section 161 CRPC by the investigating officer. Stop. Next paragraph. It appears that the petitioner is cooperating with the investigation. Stop. In view of the facts and circumstances of the case, this court is of the considered view that custodial interrogation may not be necessary for the ongoing investigation. Stop. As such, the interim order passed earlier by this court on interim pre-arrest bail granted earlier by this court by order dated 10/4/2024 is hereby made absolute, subject of course to the following conditions. 1, 2, 3 disposed of.
Obliged.
Handling item number 17.
CD is there?
CD receipt.
Immediate. Huh? Yes.
FI page 17.
Item page
17. FI page 17.
Yes, land mafia. You are Tapas Chaudhary.
Yes, allegation is there.
Is land mafia. Yes, materials.
FIR.
Here, my lord, material FIR against 3 persons, not against this person. He is not named in the FIR. But in the diary, my lord, it shows that the whole case is against one Dhiraj Chaudhary.
Not him.
Not against this person, my lord.
Now, was he on interim? No.
No.
Then let him surrender. Yes, sir. Is he coming? Okay. All right, you only take it. Heard Mr. L.K. Bora, Learned Counsel for the petitioner, stop. Also heard Mr. This was in the previous case, no? Previous case, return case diary. Also heard Mr. B.B. Gogoi, Learned APP for the state respondent. Stop. This is an application under section 438 of CRPC for granting pre-arrest bail to the petitioner, i.e. Shri Tapas Chaudhary, who is apprehending arrest in connection with Azara PS case number 261 of 2023, registered under sections 120B, 420, 466, 467 of IPC. Stop. The case of the petitioner is that, the case of the prosecution is that the informant lodged an FIR on 29/11/2023 alleging inter alia that three accused persons submitted a fake deed in miscellaneous J case number 464 of 2023 in TS number 277 of 2023 before the civil court in Guwahati. Stop. It is the further case of the prosecution that the said fake deed is connected with the accused persons and the petitioner, and that the petitioner is a land mafia, is an alleged land mafia. Stop. Mr. L.K. Bora, Learned Counsel for the petitioner, submits that the petitioner is not named in the FIR and that he has been falsely implicated in the case. Stop. Mr. B.B. Gogoi, Learned APP, fairly submits that the materials available in the case diary does not indicate any adverse material at this stage against the petitioner.
Yes.
Stop. Heard the parties and perused the materials available on record. It appears that there are no adverse material collected at this stage by the investigating officer against the petitioner. Stop. That being so, this court is of the considered view that custodial interrogation of the petitioner may not be justified for the ongoing investigation. Stop. Accordingly, it is provided that in the event of arrest of the petitioner named above in relation to the above connected case, he shall be released forthwith on furnishing bail bond of rupees 50,000, satisfaction of the arresting authority, subject to the following conditions. Number 1, surrender 10 days. Those 3 conditions of anticipatory date. Disposed of. Must be. কেটা থাকিল এই তিনটা না মেইন লিষ্টটো হৈ গ'ল মেইনটো হৈ গ'ল আৰু এটা কংগ্ৰেচুলাৰ আছে নহয়
Lordships, in item number 12, my lord.
Yes.
Lordships, may you please to record my presence, my lord. I was, Lordships, I could not attend the Lordships. I could not attend the matter. Item number 12, my lord.
Your name has been present. You please inform the court master.
It has been fixed on 18, my lord. We will appear, my lord.
12 to নাম to দি stenok কৰি দিলে হয়
Next Friday, my lord?
Yes. Do you want it at 2 o'clock?
2 o'clock.
List for further hearing on such and such date at 2 p.m. I'm not recording anything about the CD. You have a look at it, and if there is anything, you flag it. Both sides.
Deep look.
Because otherwise, arguments are all completed.
Yes.
We just have to see if there is anything against
Only
Deepshika.
because of that endorsement by the
Correct.
some food.
Give it on that day. Because I am not yet keeping the file with me. It might get lost. On that day, I will see. All right.
May it please your lordship. This matter has been pending for quite some time.
Yes,
there was
looks
a
like
direction in the month of
2013.
Yes, in fact there was a direction by the Honourable Court on 18th of January. In fact, in the open court, when the argument was on the verge of completion, Honourable Justice Debashish Barua.
Why nowadays you all name the judges?
No. I have a specific
What is the reason for? I have been noticing this is a recent trend.
No. It's nothing like that because this matter has been heard on several occasions. That is why I just want to point it out.
Is this matter part heard?
No, it was not part heard. In fact, had it been part heard, probably by now it would have been disposed of. Anyway, what had happened, the court had indicated that if the petitioner number 2's land on whose this establishment was there and it was demolished by the Coal India authorities, then normally it should have been from some authority. The court wanted to know as to whether it was his premises or it was the premises of some other
Which
person.
is that order?
18.1. It was not particularly reflected in the order, but that was partly indicated during the course of hearing.
Ms. Barman, were you present on that day?
No, she was not present.
Earlier,
I think one
Sharma was there, but
N. Goswami was there. N. Goswami.
No, what do you want now?
No, what the thing is that the government person there too was supposed to file affidavit. On 2 occasions they could not.
You see, if there is no noting in the order as regards what is to be filed, MS Barman will not be of any help to you. She can't do anything.
But if your lordship peruses the order of 18.1...
That's why I'm asking you if it is recorded in the order.
It was recorded as to whether the land covered 18th of January.
18 January
2024.
24.
May I read the order?
One sec, let me first find the order. Yes.
Mr. N. Goswami, the learned government advocate appearing on behalf of the Circle Officer Margarita.
This is not yet done?
Not yet been done.
Then, Ms. Barman, you get this instruction?
She has got some instructions,
my
I am
lord,
told.
Thereafter, as next date instruction was not received, my lord, probably this matter was again listed on 27/3, my lord. Wherein Mr. H. Sharma was appeared, and same thing has to be brought on record again, my lord. Pursuant to that, my lord, I have received a small instruction.
Does it fall within the schedule of the Coal Mines Nationalization Act?
That record we do not have, my lord.
That is what is the
query. That is the
precise query.
Mutation we have found, my lord. Mutation, regarding mutation, that is
but the precise query is that, correct?
Yes.
And I think that has some bearing on the issue that has been arisen in this petition. Correct, Mr. Ahmed?
Reflection
so
of my
have the specific information.
Reflection of my instruction says, my lord, there is a need of joint survey within that coal authorities because no record is available pertaining to that Makum coal field, my lord.
No, but if that is required, why do you want an order from this court?
No, it's a request on the part of request.
Information. Can that not be done?
They don't have any information regarding that.
No, the joint survey?
No. Kindly peruse this instruction.
Mr. Ahmed, you are appearing for the coal mines. Is recorded in the name of Royal Coal Products, owner so and so. For this, also stated that no record is available whether concerned land falls within the schedule.
Yes, that schedule is
The report
in
number
56, my lord.
No, but
Act.
then that has to be looked into.
Yes, my lord.
This instruction is of no help.
Yes, my lord.
So what is to be done? Yes, Mr. Ahmed.
Can I pray for a joint verification with the district authorities as well as the coal?
No, that is why I am
India,
asking
my lord.
let Mr. MJ Ahmed also. Yes.
Stated that the report submitted by the circle officer Margaret
Is enclosed herewith.
is enclosed.
But I don't have it. I don't have any report.
In fact, in my instruction also, it's a soft copy, my lord. Hard copy
No, but
probably yet
be that as it, you see the report. In terms of the report, it
My lord.
appears that the it does not disclose as whether this land falls within the schedule or not.
Yes.
Most likely, because this is what the forwarding letter says, correct? So we will take it that probably the circle officer's report does not indicate. Otherwise, it would have been mentioned here. Now, if that is so, because since this is a matter pertaining to 2013, I don't want to unnecessarily delay the matter further. Let us see how to progress, correct? Probably one way out is that if there is an inquiry.
Inquiry as well as the participation of both the parties, my lord.
Correct.
Joint
So
verification.
if, shall I
may be allowed
direct
to
that?
produce
Yes. Now, it can be done. Now, who do I direct the inquiry to be done, conducted? Mr. Ahmed, who should I direct? Circle officer has already given his report.
Email.
I guess Ms.
Deputy
Burman?
Commissioner would be the appropriate
Ms.
authority.
Burman?
As per my lord, if a matter has to be relegated, I have in fact that Act, my lord.
Yes.
73 Act, my lord.
Yes.
Coal Mines Act. There is, I don't find any nominated authority, my lord.
No,
So-
if you do not, if at this
For
moment,
the
if you do
purpose
not
of
have that
joint- for the purpose
instruction,
of joint
then I can
verification,
post this
my lord,
matter
we say.
tomorrow. You have the specific instruction
For
as
that
who
matter,
do we
my lord,
direct?
joint, the
Huh?
Deputy Commissioner may, my lord.
Deputy Commissioner.
Because
Yes, sir.
record,
Maybe the-
any record is to be available, that is within his office, my lord.
So I shall direct in the interim to the Deputy Commissioner,
Deputy Commissioner.
to conduct the inquiry.
Inquiry, joint survey, whatever they would like to,
Along
my
with
lord.
the general manager of
Obviously, my lord.
Joint
both sides.
survey.
I am
No,
applying
I
for.
will say it's a joint survey.
That will
Because
be better.
so far
because
Along with
along with the parties here too. The Coal
that
India.
can't be. The inquiry will be conducted by the
hey,
DC.
Deep DC.
So
But
maybe,
probably since the spirit also
all right,
doesn't have.
let us do it like this. Let DC conduct the inquiry where all the parties will
have to
participate and
yes.
I think, is that okay? Because at the end of the day, it's the domain of the DC to find out where the
Ultimately,
land
my
is,
lord.
isn't it?
He has to find out
He
the
has to
record
find out.
somewhere else, where it is, my lord.
another prayer submit that the DC also produce the record of the mutation done.
Mutation is done.
Mutation is in their favor. But Act says so whenever this, under the coal mine, my lord, that cannot be done, that is their pleaded case.
All right, we'll come to that after some time.
Well.
Lekha. Pursuant to the order dated 18/1/2024, directing the state respondent to obtain instructions to apprise this court as to whether the land belonging to the petitioner, as stated in paragraph number 3 of the affidavit filed by the said officer, i.e., the land covered by NLR grant number 2 in DAG number 160, measuring 2 bighas 1 katha 4 lecha, falls within the schedule to the Coal Mines Nationalization Act 1976. more particularly in respect to Makum coalfield.
Yes.
Stop. In nationalization to within bracket. Today when the matter was called, comma, Ms. M. Barmon, learned government advocate for the state respondent, submits a letter dated 23/4/2024 issued by the additional district commissioner within bracket revenue Tinsukia to the office of the additional senior government advocate Assam, stating that pursuant to the order passed by this court as mentioned above, comma, the circle officer Margarita, Revenue Circle, submitted a report however, there is no record available in Margarita Revenue Circle as whether the subject land falls within the schedule to the Coal Mines Nationalization Act so and so. Stop.
In respect of Makum coalfield, probably that will.
More particularly in respect of Makum coalfields. Stop. A copy of the aforesaid instruction is placed before this court, which is marked as X. Executable. Stop. Next. Considering that there is no record available in Margarita Revenue Circle as regards whether the concerned land falls within the, as regards the status of the subject land, comma, this court is of the considered view that until and unless the status of the subject land is verified, comma, the instant writ petition cannot be effectively adjudicated. Stop. As such, this court directs the jurisdictional district commissioner to cause an inquiry in the matter specifically as regards the status of the land and submit before this court. Stop. Needless to clarify that in the inquiry conducted by the jurisdictional district commissioner, all the parties concerned shall duly cooperate and participate. Stop. Okay? It is needless to it is further clarified that the said exercise shall be completed within 2 months, 1 month?
2 months, I think it will
within
be.
2 months from the date of receipt of the certified copy of the order. Stop. List this matter after 3 months, after 2 months and a date before. I'm posting it after 2 months.
September 3rd.
Okay. One of you submit the certified copy. That effective portion of the order is correct, isn't it? DC to
Jurisdictional commissioner would be respondent number 2. We have made him a party.
Within bracket R2. Okay. Anything?
That may be furnished.
Further, it appears that the record of the mutation of the subject land would be necessary. Also, would be necessary for effective adjudication of the matter. Stop. let the Government Council produce the same on the next date of listing.
In fact, Your Lordship, may I just suggest one thing? Could it be just put it on affidavit, both the report and as well as the mutation record and all?
That is, whatever is there is there.
That will be binding on the authorities also.
No, you're right. You see, if the report comes, we may ask them to place it by affidavit, and but otherwise,
I think that report has to come first.
yes, and mutation records may be big. I don't know.
May not be.
Sitha copy may not be possible to bring on record, but I can make statements.
Ms.
on
Borman, if you receive it
My lord.
prior and
I'll try
there's
to file the
time,
affidavit.
you file it by way of an affidavit. Otherwise, you bring it on third.
Original copy may be produced for court's perusal. My lord.
All right.
Oblige.
Oblige, Your Lordship.
Are you appearing for the petitioner? Why were you absent on the other day?
My lord, we were in a different court.
We are in a different court cannot be a ground for not appearing in another court. You should have made sufficient arrangement. You could have requested a friend. Huh?
My lord, I apologize for not appearing.
Not, no problem. All right. When do you want it?
Any date.
This matter was listed today in view of no representation on the last occasion, i.e. 11/6/2024, with the remark in the cause list within courts for dismissal. Stop. Today, when the matter was called, MS
S. Vaishya.
MS S. Vaishya, learned counsel for the petitioner, is present. Stop. Respondents are also represented through their respective counsels. List this matter for further consideration on?
Any date may fix.
Yeah, 2 weeks of the date. Alright.